Yes.
Number 60. This matter has been signed with
60. Yeah.
particular track. This matter appeared as a regular for your lordship. Considering that Order 21 Rule 99 rejection, after a prolonged delay, this appeal has been filed, directed the affidavit to be exchanged in respect of Section 5. Challenging that order, they went up to the Honorable Supreme Court and obtained an order of stay of execution. But I am humbly visiting lordship that it's an order where the eviction has been affirmed up to the Honorable Supreme Court. Direction was there to file an undertaking right before the Honorable Supreme Court.
We cannot update, right now we cannot update. No, because frankly speaking, Mr. Mukherjee, this bench was sitting with limited jurisdiction. But now so many matters have been assigned. Virtually, we are having too many determinations. So we cannot give any precedence to assign matters right now. We have to take up our prime determination first. So not right now. Yes.
The leave of justice, my lord, have you lordship kindly to mention a matter, my lord, for only for correction?
Yes.
The lordship, I am appearing in person.
Right.
The case has been assigned.
But you are an advocate.
Yes, I am an advocate.
Yes. Can you please take the microphone?
I am appearing in person. Dr. Devipal appeared in the case from the very beginning. Thereafter, I appeared. The company where I work as an assistant manager, that company was no more existed, and Eastern Railway has taken its property, but not the company.
What are you wanting now? What are you wanting?
Now, the case has been assigned to your lordship on 14. Now I'm going for operation. I got hard block. The case may be good at the earliest. My only pay is 23 months salary.
What is the item number?
I signed the husband card, but that was not listed.
Can you please give the number?
Yes, your lordship.
Whenever the file comes, it will be given in the list.
File has come on 14.
Here in court, it has to come. Whatever assigned matters are sent to our court, we are giving in the list. If it has come or it will come today, we will give it in tomorrow's list. Don't worry.
Lordship, may I be permitted? I am mentioning the matter including in the list for hearing as well, Lordship.
What is this? What matter?
Specific performance of contract, my lord.
We have determination. We don't.
Yes.
What yes? Specific performance, we don't have determination. We don't have determination. Please check up whether you have determination first.
My lord, may I be permitted to mention, my lord, with notice, my lord, I am mentioning this, my lord, hearing. My lord,
What matter, Mr.
My lord, this is land matter.
Hand over.
Intention of interim order.
Yes, please hand over.
Application in connection with Group 8.
Hand over.
My lord, for inclusion, supposed to be listed on last Thursday.
What? Hearing?
Group 8 appeal matter, lordship, mandamus appeal.
Appeal, you are taking too much matters, too many matters.
Already, but there are certain
today we will be taking, but from tomorrow we will be considering. Appeal, yes. Today, since we are taking everybody's appeal, yes. Hand over.
A very minor typographical mistake, lordship.
The case is lying in RDA, so the case should be.
What is the matter?
The case was dismissed on default.
Have you filed a restoration application?
Restoration, yes. On agree.
Are you mentioning the restoration application?
Yes, my lord. Your lordship, you are pleased.
Listen to the question, then answer. Is the restoration allowed?
Yes, sir.
What are you wanting now? The appeal to be heard?
The case is.
You want the main appeal to be heard?
NRDA. So the case record should be brought.
No, we won't bring records unnecessarily. Sorry. Yes.
May I have your lordship to mention item number 20 and 21 of today's list? Well, we also sought for an adjournment on Thursday on the ground of Mr. Shah being indisposed.
When it is called on for hearing? When it is called on, inform the other side. Yes.
Mention for an application for
Yes.
Right, my lordship.
Yes.
Lordship, may I be permitted to mention for inclusion of an application, my lord?
Yes. Are you wanting hearing of the matter?
Hearing.
Yes. Hand over the slip. Then, call.
Lord, in item number 1,
yes,
my lord,
yes.
I beg to appear on behalf of the appellant, my lord. As per your last order, your lordship, my lord, there was a direction that I had.
Service.
No, my lord, there is a change. There is a change in the situation, my lord. After I filed the affidavit of service, my lord, the post got delivered to the address. Now, my lord, in the affidavit of service.
Learned counsel for the appellant files an affidavit of service. So it is submitted that subsequent to the affirmation of the affidavit of service, the postal track report was obtained, which shows that service has been delivered. The printout of the postal track report along with the affidavit of service are kept on record. Next para, the matter, this is a what is the suit for matrimonial suit or what?
My lord, this was a matrimonial suit challenging an order against 27 clause 3, my lord.
Since the matter arises out of a matrimonial proceeding, we are of the view that the matter is fit to be sent for mediation. So accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. Thank you.
Grateful. My lord, shall I communicate this order to the Calcutta High Court?
Yes, please do communicate to whoever, to the committee also. The file will automatically go, but you can make your own communications.
Grateful.
Thank you. Two. পেপার বুকটা দেখি পেপার বুক আছে ফাইল গেলে তো পেপার বুকও যাবে None appears for either of the parties at the time of call. Full stop. The matter arises out of a matrimonial proceeding and accordingly is deemed fit for mediation. Let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. Next.
Madam, for the appellant.
Appellant for the respondent.
These are the service.
Arises from a matrimonial dispute.
Suit was filed and that is dismissed, and therefore this.
Let us send it for mediation. Let us have a chance. Yes.
I'm being led by Advocate Abhishek Prasad. Lordship.
Mr.
Abhishek Prasad, Lordship. In this matter, Lordship, the Lanet Court awarded me a maintenance of rupees 5,000 rupees till the disposal of this proceedings. Now, Lordship, till date, that amount is to be paid, Lordship.
No, trial court directed you to pay.
Yes, Lordship.
That is over when the decree is passed.
Lordship, several executions are still pending, Lordship.
No, those executions may carry on, but
Lordship, I'm completely.
If there is a mediation, that mediation will make it clear. We'll record your allegation that they are not paying. Execution cases are pending, and we'll say that those non-payment, those issues of non-payment shall also come within the purview of mediation.
Yes.
If they pay up the entire thing, you agree to mediation. If you don't agree, you come back.
Area as well as the current, Lordship.
But we'll record that. Should we record a dispute of that?
No. Kindly record that there is a proceeding under section 125 of the CRPC. There is an order to pay rupees 1,500, and till the date, I have instructed.
Which was a greater amount.
5,000.
But that amount I don't have instruction as because the order I didn't find.
Affidavits of service filed today be kept on record. First of
Last 27 years, we are.
The matter arises out of a matrimonial proceeding. First of learned counsel for the appellant submits that the parties are residing separately for the last 27 years. First of next para, learned counsel for the respondent wife submits that despite an order of alimony being passed by the trial court, the husband has not been paying the same, for which several execution cases are pending. First of learned counsel for the appellant husband submits that the husband is going on paying pursuant to an order passed under section 125 of the Criminal Procedure Code. First of next para, be that as it may, since the dispute is matrimonial and there is a fair chance of mediation, we are of the opinion that the matter be sent to mediation. First of we, however, make it clear that all issues raised by the parties, including the question of payment of maintenance to the wife and arrears, if any, shall come within the purview of the mediation proceeding. First of next para, accordingly, let the matter be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. If you don't agree, come back. Always that option is open to you.
Item 2.
But these trained mediators are very good, we are telling. We have some experience.
As your Lordship pleases.
Let us take a chance. Next.
So far as item 2,
we have recorded an order, sent it to mediation.
I have, my lord, sent him notice. This much I can.
No, but we have recorded an order that none appears to suit. You keep that with you, Mr. Mitru, it may be recorded in mediation that a notice was given. Keep that with you. But we have recorded an order, none appears to. Yes, who is appearing in this?
Item 4, I am for the
Eta ki? Acha. Yes.
Item 4, I am for the respondent husband.
Matrimonial.
Matrimonial.
You agree or do not agree?
2014 divorce degree passed.
Pardon?
Divorce degree passed on 2014.
You are enjoying the divorce degree.
Let it go for me.
So have a reconciliation. Yes. If you agree to part ways, you are for the appellant.
Yes, my lord.
Your phone is also for the appellant.
Not.
Or you have any objection to this reconciliation? Very well. Heard learned counsel for the parties. First of on instruction, learned counsel submit that the matter arises out of a matrimonial dispute and there is no objection on the part of the parties to explore the option of mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation between the parties. Thank you. Yes. For Tribunal. Yes, Mr. Mukherjee, what is the matter?
Agree, sir, Mr. Lordship, I have served. I have been informed that private respondent's item has been delivered.
You are for the state.
Private.
Private respondent has received.
Yes, ma'am. I am delivered.
You are for the private respondent.
Yes.
State who is appearing. You are appearing for whom?
Lordship, along with me.
Acha. Is for the state.
Item number 5. Oh, I'm sorry. I'm sorry, my lord.
You have served state also?
Lordship.
Yes.
Lordship,
What is the matter?
Lordship, kindly before going to the...
We won't.
The Lordship,
Hear you.
we
Yes.
initially filed an original application. We are the owner of a civil property. Now, the civil property is private respondent is a borgadar of the civil property. Lordship, due to non-payment of the share in terms of the provisions of the West Bengal Land Reforms Act.
Give us half a minute. Hey, apni na Land Reforms Act rule ta diye rekhe din. Ye adhik matter Land Reforms.
Lordship, it will, Lordship, these rules and, Lordship, the regulation, rules and manual is...
We'll come to that. You finish, just we are taking them. Yes.
Now, Lordship, for the purpose of termination of borgadar, now, Lordship, we initially filed an application, original application before the West Bengal Land Reforms and Tenancy Tribunal. Now, West Bengal Land Reforms and Tenancy Tribunal directed the concerned respondent to initiate a bhagchas case because the borgadar is not delivering the share. Now, Lordship, on the basis of the order of the West Bengal Land Reforms and Tenancy Tribunal, 2 cases has been started, 30 and 31 in the year 2016. Now, both the cases, Lordship, the concerned subdivisional officer directed to deliver the share and, Lordship, such quintal of, Lordship, the crops, as well as alternatively, this amount has been specified to paid in favor of the owner of the agricultural land. Now, Lordship, they failed. Now, subsequently, Lordship, we filed an application for termination of the borgadar. Now, Lordship, the termination of borgadar during the pendency of this application before...
This land was within your ceiling limit.
Within the ceiling limit. Now, Lordship, during the pendency of my application, they preferred an, Lordship, appeal before this, Lordship, the appellate authority.
Against that order of the SDLR.
SDLR.
Right.
Now, Lordship, subsequently, they alternatively filed an application before the West Bengal Land Reforms and Tenancy.
Appeal was before which authority? The appellate authority.
Appellate authority. That is the DL and LRO.
DL and
Land and Land Reforms
right.
Officer.
And also before the tribunal.
Tribunal.
Against the same order.
Same order.
Right.
Now, Lordship, we got the order of termination of borgadar. Finally, got the order of termination of borgadar.
From which authority? Appellate authority affirmed?
No, from the some subdivisional officer. Who is the authority? Prescribe authority.
That you have already got his challenge. You said that.
Now, Lordship, the initially payment order, which was initially passed by the revenue officer, that was under challenge.
Achha. Not the termination.
Not the termination order.
The termination order was never challenged by them.
Never challenged by them.
All right. Then?
Now, subsequently, Lordship, when I got the termination order, Lordship, the appeal which is the preferred, this appeal has been dismissed because appeal is infructuous because termination has been made. Now, Lordship, and also on the ground, because on the self-same issue, on original application was pending before the West Bengal Land Reforms and Tenancy Tribunal. Now, West Bengal Land Reforms Tenancy Tribunal also dismissed their application. Now, this is the issue. I have filed...
Is their application tribunal dismissed on the same ground? Infructuous?
Infructuous. Lordship, as because appellate authority dismissed this.
Right.
Now, Lordship, I filed an application before the revenue officer for the new cause of action that borgadar has been terminated. So let me the record of the borgadar be deleted and record the new borgadar be, Lordship, inserted in the record of rights, LR record of rights.
New borgadar?
Yes. Now, new borgadar means who is now cultivating my land.
Achha, very well. That has to be recorded.
Now, Lordship, the inaction of this concerned revenue officer, I filed an application before the West Bengal Land Reforms and Tenancy Tribunal, which has been rejected on the ground that the termination order passed by the subdivision officer is wrong.
That was beyond the scope of the...
Beyond the scope of this Lordship limit, because we have not prayed for, there is no cause of action to challenge this order. But Lordship, this tribunal has observed this order is non-est. So Lordship, I am not entitled to get an order of recording the
Let us
name
see
of
that
the
order for
beneficiary.
once.
Lordship, kindly
Last
come.
page, last page.
I will
Last
come to the impugn order. Lordship, kindly come the initial order, that is page 12.
No, first let us see the impugn order. We'll go back.
Last page, my lord.
Lordship, may I place entire order? Lordship, starts.
You place in your own way. We'll also read in your own.
I'm sorry. In section 76.
Mr. Mukherjee, before going on to your learned friend, we are asking you something. Yes, we appreciate that both the challenges against that first order,
Yes.
which was dismissed. The appeal against the termination order was also preferred for subsequently by them. That is still pending.
No. Kindly come to the
Court finds that section 18 order was appeal against section 18 is still pending. The termination order has been challenged in an appeal by them, which is still pending. Your initial order, your initial challenge to the order, whereby the produce was directed to be paid by them, that appeal was dismissed.
Lordship, may I place?
Yes.
Kindly come page 50.
50?
Yes.
50?
15.
15.
Your Lordship, the instruction is
Lordship, this is
15 is the affidavit page.
Oh, sorry. This is a page number. Page 18. Lordship, kindly come page 18. Lordship, problem is Lordship, both
Two sets of pagination. Yes, page 18.
Page 18th is the proceeding which was initiated for recovery of share. This is Bhagcha's case. Now, Lordship, kindly come the last order, last page 21.
Yes.
Now, Lordship, this is the order. Kindly come.
Directed to pay the money or the produce. Yes.
The produce.
Yes.
Now, Lordship, the kindly Radhasyam Das, who challenged this order before the Lordship, as per the provisions of law, before the appellate authority, that is page 22. Now,
we agree. Mr. Mukherjee, the challenge has ultimately failed against this order, this page 18 order.
Now, kindly come termination order at page 26.
Yes. Termination order.
Page 26. Order dated 26 February 20.
Be terminated. Yes.
This is not under challenge.
They say that this is under challenge before the appeal number has also been given. Probably the appeal number is given. Let us just check up.
Appeal number is given, that is
30 and 31, that is what?
31, 31, that is Bhagcha's case.
There is a previous one.
That appeal has been dismissed.
30 and 31 are two appeals.
Two appeal. Now, 31, 30 in Bhagcha's case.
That is a case number, right?
That is case number. Bhagcha's case, that is reached to the finality because directed to pay the share. This order was, now Lordship, the same OA number 3024 of 2020, that is also dismissed.
No, at page 2 of the impugned order of the tribunal,
Yes.
the third last paragraph, they say, on the other hand, learned counsel for the private respondent 3, say that you have suppressed what you have suppressed. You have never disclosed that one appeal has been filed challenging the order of the Bhaksha's officer. Which office? Which order?
This Bhagjas case order, Lordship, that is, Lordship, I have just now shown that page 22, that is dismissed.
That order. 26 has not been challenged.
No. 20's order, termination order, till date, not has been challenged.
Apparently, that was the mistake committed by the tribunal. It was an impression was given that an appeal is pending because page 3 of the tribunal's order, if you come to the second on careful examination, the last sentence of that, moreover, in an appeal petition, being number is given, wherein the order passed by the empowered officer under section 18 is under challenge. Please show us the order passed in appeal number 366 of 2019.
Yes,
that has,
I have annexed.
Please show us that order only.
(366).
The order passed in 366.
Lordship, may I have the indulgence to submit one thing?
Yes, kindly come page 22 and dismissal order is.
No, the appeal.
Yes, appeal number, kindly come page 22, top. This is 2019. That is dismissed. Now, Lordship, what is the report of the state? The report of the state is for the correction. Lordship, the learned tribunal has not gone into the report of the state. The report of the state is that for the correction of record of rights, they have to collect the instruction from the district authority. So that has not been considered. That is pending before the district authority. Unless only until the instructions come to the BLRO from the district authority, they are unable to correct the record of rights. This is the only issue of the state. Kindly come to the impugn order. The government representative of the state has submitted that from the status report filed by the BL and LRO Dubrajpur, Birbhum, it is quite evident that he has taken all steps from his end and sought for approval from the DL and LRO Birbhum for correction of ROR, for which the allegation of inaction.
So further approval is required from the DL and LRO?
Yes, the approval is required according to the BLR. That is pending.
Under which provision is approval required?
So I don't know, because section 50 that nothing, Lordship. Now, Lordship, kindly come to the provisions of law. Yes, approval. Kindly come
it is evident from the impugned order of the tribunal that the tribunal mistook this appeal number 366 as an appeal against the termination order.
Yes, that is not.
That is the premise.
That is the delivery of SARE.
So before coming to the law, let us hear them. What is the what is your stand? No appeal is pending under section 18. The number given is regarding this. We have that order. No basis of this order.
First of all, my lord, Sukumar Patho, after that, my lord, his legal heirs of Sotto Kinkor Patho. But he is not a only owner. Other co-sharer is there, my lord. If file
so you don't have any point on merits.
My lord.
Therefore, you don't have any point on merits.
My lord, Borgadar is trying to produce the share, my lord. He did not receive the share.
You are the Borgadar.
Yes, my lord. He did not receive the Borgadar.
Offering a termination order. So therefore, the records have to be corrected. You are no longer a Borgadar. You have not challenged that. There is nothing on record to show that you have challenged the termination order under section 18.
My lord,
366, it is evident from page 22, as rightly pointed out by Mr. Mukherjee, that 366 is the appeal against this, your direction to give the produce to him or the money.
But then may I take an instruction, my lord?
No instruction. You will have your instruction in our order.
My lord,
you will direct the records to be corrected. Sorry. There is no appeal pending at your behest. You are for the state. You are recording your presence.
I am not engaged in this matter. I was asked to take.
We're in the middle of a matter, ma'am.
Yeah, Lordship.
Please don't disturb the court like this. Yes, thank you. Despite service, none appears for the state. Although the private respondent is represented through court. Push up next para, learned counsel for the petitioner submits that by the impugned order, the learned tribunal proceeded on a palpably erroneous premise that an order of termination of the Borgadarship of the private respondent under section 18 of the West Bengal Land Reforms Act is pending, and on such premise, refused to pass a direction on the BL and LRO to correct the records of right pursuant to such termination. Full stop. Next para. Learned counsel for the petitioner submits by way of a brief history of the matter that initially a proceeding was filed by the present writ petitioner stroke owners for a direction on the private respondent stroke Borgadar to pay his share of the produce. Full stop. An order was passed to that effect, comma, which was challenged by way of an appeal bearing number 366 of 2019. Full stop. During pendency of the appeal, comma, and a parallel challenge against the self-same order before the Land Reforms and Tenancy Tribunal, comma, the...
We challenge the appeal not dispose of the, that is why we challenge the...
An order of termination of the Borgadarship was passed under section 18 of the said act. Full stop. In view of the termination order having been passed, comma, the appellate authority, comma, by way of an order bearing order number 3 dated December 6, 2022, comma, dismissed the appeal, comma, bearing number 366 of 2019, comma, thereby recording that the final order of termination had been passed and that a parallel challenge against the self-same order was pending before the tribunal. Full stop. On the other hand, comma, the tribunal, comma, video order dated February 18, 2025, comma, dismissed the challenge preferred before the tribunal, comma, on the recording that the challenge had become infructuous because the DL and LRO Birbhum had already disposed of the appeal and appropriate steps would be taken against the order passed by the DL and LRO Birbhum. Full stop. Next para. Learned counsel for the petitioner also places reliance on the order bearing order number 4 dated February 26, 2020, passed in the proceeding under section 18 within bracket 1 within bracket small b of the West Bengal Land Reforms Act 1955, whereby the Borga right of the recorded Borgadar, of the then recorded Borgadar, that is the private respondent, comma, was terminated from the records of right. Full stop. Next para. Learned counsel for the private respondent submits that an appeal is pending against the order of termination. Full stop. However, comma, no number thereof is disclosed to us. Full stop. Rather, comma, from the impugned order of the tribunal, comma, it is clearly reflected that an impression was given to the tribunal that appeal number 366 of 2019 was pending against the order of termination under section 18. Full stop. Next para. However, comma, from the records annexed to the writ petition, comma, which are certified copies of the said appeal itself, comma, it is clearly evident that the appeal had been filed not against the termination order, but against the initial order passed upon the private respondent stroke Borgadar to furnish his share of the produce in favor of the owner. Full stop. The said appeal having already been dismissed as infructuous, comma, the order of the learned tribunal was perverse, comma, inasmuch as the said order was based on no material at all. Full stop. Next para. In view of the above, comma, we do not find any scope of the tribunal dismissing the application of the petitioner for correcting the records of right by incorporating the name of the current Borgadar, comma, in view of the same being merely a corollary of the order of termination of the Borgadarship of the private respondent. Full stop. Accordingly, comma, WP LRT 108 of 2025 is allowed on contest against the private respondent, comma, thereby setting aside the judgment dated March 21, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 736 of 2022 within bracket LRTT, bracket closed, and directing the concerned BL and LRO. Is he a party here? being respond number 3 herein, comma, BLLRO যেখানে বললাম BLLRO, comma, Dubrajpur, comma, being the respond number 3 herein, comma, to immediately correct the records of right by reflecting the name of the current Borgadar and cancelling the name of the private respondent as a Borgadar from the concerned records of rights. Full stop, such corrections shall be carried out at the earliest, comma, preferably within 1 month from the date of communication of this order to the respondent number 3. No orders to cost.
Your Lordship, one indulgence. Supratim Dhar, learned counsel is appearing in this matter for the state. Kindly, he was.
The matter is over, ma'am. Next. ডাকুন। শোনা যাচ্ছে। ওখানে দেখা যাবে না, মুখে জোরে ডাকুন।
My lords, in item number 6, there are nearly 48 private respondents, my lord. Due to certain technical errors in the Indian Postal Service, I could not procure all the track reports, my lord. Kindly.
Why did you mention the matter then?
Well, it was listed. It was
automatically listed.
Automatically. Day's accommodation may be given. I'll come back tomorrow, my lord. A day's accommodation may be given.
Day's accommodation, how can you come back?
My lord, let me check, my lord. That track report has been uploaded.
I am appealing for few private respondents.
Oh, few won't do.
I am appearing for the respondent number 7, 8, 11 to 20.
You check out between yourselves whether you cover, both of you cover all the
check
come back tomorrow.
My
Learned counsel for the petitioner submits that all the private respondents could not be served and see.
It has been served or not, I'm not sure. But
Acha. Learned counsel for the petitioner submits that it is to be ascertained as to whether all the private respondents have been served and seeks a day apostrophes accommodation. First of let the matter stand adjourned for the day. Whoever is appearing for the private respondents, you please check among yourselves whether you between yourselves you cover all the private respondents. Whoever is left out, please point out to your learned friend who is taking his notes and not listening. Point it out to him so that he can take instruction regarding those. Thank you. Not today. Next. Please have a sitting with them and check up who they are appearing for. The rest you have to satisfy.
7 losses. I am appearing with the petitioner loss.
Yes, Mr. Das, what is the matter? You have served on all?
Yes, loss. Service loss.
Any private respondent?
No. Only state is the party loss.
Good service?
Yes, loss.
Yes, what is the matter?
Loss, due to my convenience, I supplied a list of dates. Loss, petition.
Why is the state not appearing?
Loss,
afraid of you or something?
Loss, I do not know.
State generally appears at least.
Loss, petitioner is the charitable trust run a school for the poor people, poor students of the village. That school was situated.
It's a private charitable institution.
Private charitable institution. The school was run. The petitioner made a representation before the concerned Panchayat Samiti in the year of 1993. One land, government vested land was there, plot number 21. Subsequently, that plot was divided to two parts, plot number 21 and plot number 21 by 156. Plot number 21 is the pond and plot number 21 by 156 is the bank of the pond.
So you are running a school over there?
Lossy?
You run a school, you said?
Lossy.
In the pond?
No. Just site of this land property.
So it's by definition fishy?
Lossy. Plot number 20. Thereafter, Lossy, my petitioner made a representation before the Panchayat Samiti for getting that land to use for the purpose of run of the school. In the year of 1993, Panchayat Samiti granted the permission to utilize the said land.
Panchayat Samiti was the owner of the land?
No, vested land, government vested land.
Vested land, but Panchayat Samiti, why did you have...
I showing this rule losses thereafter loss. Thereafter loss.
Gave you the permission to run a school?
Run a school by utilizing that land. In the year of 2007,
that permission was given in respect of 21 by 156.
Both.
Pond you cannot run a school.
No, pond can water of the pond can be used
for the purpose of the school. Very yes.
Thereafter, in the year of 2017, a petitioner also made a representation before the Gram Panchayat.
Which year?
2017.
And that permission was given when?
Initial permission 1993.
All right.
Page 17 lawsuit in the writ petition.
Page 17.
Yes.
Very good.
2017, petitioner also made an application before the concerned Gram Panchayat. Gram Panchayat also given permission to utilize that land. That was page number 18 and 19. Thereafter, lawsuit petitioner made a representation before the 2019 before the Secretary Government of West Bengal Department LR and RR paying for long-term lease. Page 20 lawsuit. 25th July 2019, petitioner also made a representation before the Jila Parishad.
Before the?
Jila Parishad. Jila Parishad forward the application of the petitioner before the DL and LRO, page 44, for granting long-term lease. Thereafter, lawsuit petitioner made another application in the year of 2021, praying for granting long-term lease before the DLL and LRO.
So the earlier ones were pending?
Lost pending.
Then what happened? Ultimately, what happened?
Ultimately rejected my application.
DLLR rejected?
DLR rejected. Thereafter, I challenged before the tribunal. Tribunal also rejected. Lastly, I placed 2 orders.
Isn't it their discretion, Mr. Das, to give you a lease or not?
Discretion.
Where is the question of challenge?
Challenge because of the lawsuit.
You quarrel with me in open court so that I release the matter, get it assigned before some other bench where you can convince.
No.
Otherwise, no chance.
Lawsuit, kindly, I'm showing the rules.
Absolute discretion.
Lawsuit,
no rule can be there which compels the state to give you a lease.
No. Lawsuit,
your otherwise, whatever permission is given, that remains. But long-term lease is their discretion.
Their discretion, lawsuit rejected on the ground of tribunal. Lawsuit, kindly short order of the impugned order. Lawsuit, kindly see.
Sure.
The impugned order, lawsuit. Page 54, lawsuit.
It's shorter than the breadth of the stamp.
Lawsuit.
Yes.
Lawsuit, peruse also the document. This is a letter issued by the Additional Secretary of Government of West Bengal. The applicant school have paid for long-term settlement of subject plot, which is...
They say it's a water body, but you say it's a bank along with the water body.
No, lawsuit, they are another one, lawsuit. Whatever, and there is a clear embargo regarding conversation. I never paid for conversation.
Conversation you are also not paying now. Conversion you also did not.
No, never paid. A bank of the river I used already permission granted by the authority.
So thus, this is a typical case of wrong reasoning, right conclusion. We'll supply the reasons and affirm this order.
Loss in my...
Yes, you are right. You never paid for conversion. You ask for building of a school, not on a pond, but on the bank of the pond.
Bank of the pond. I paid for pond. Why? The subject of pisciculture was introduced by school, but because of the school was situated near the sea coastal area. So many persons are engaged in the pisciculture.
That's a noble purpose, but we cannot compel the state is the owner in a sense.
Yes, Lossi, only
compel to grant a lease.
Lossi, I cannot compel Lossi.
Did they reject the dealer? Reject or inaction?
Lossi
rejected.
See the dealer order. Lossi.
Whatever.
That was also not reasoning. Lossi.
Need not give any reason even.
52 Lossi. Page 52.
না রিজনটা ভুল দিয়েছে ও বলেছে কনভার্সন চেয়েছে কনভার্সন করা যায় না ও কনভার্সন চায়নি না হ্যাঁ ওসব বলবেন না তাহলে এখন আবার এডুকেশন শিখিয়ে দেবে My learned brother is saying there is no curriculum in the education in the syllabus regarding pisciculture. Is it true?
Yes, I made an application to that extent.
There is a scope of teaching pisciculture in the
yes.
In syllabus there is.
Yes. I made an application to that.
We are not disputing that. Yes.
Page 52 lawsuit, rejection order of the authority concerned. Last paragraph lawsuit. Nothing was reasoning. Only rule 272 and 273 is not permitted. So my application was rejected.
You wanted only for the water body?
No.
Where is your application?
My application lawsuit, last application.
Previous page. 49.
Lordship, my last application, Lordship.
Yes, both the
Page 49, Lordship. Page 50, Lordship. Last paragraph. Area also mentioned. Butter plot 12 decimal and pond is 68 decimal. And page 50, first paragraph, I also see middle portion. Most of the students are from the poor family of the fishermen.
You have not yet got the subject in your curriculum. You want to just grab the pond and for that purpose to introduce. It's not there in your curriculum till date. You are wanting to introduce it for that purpose. You are wanting to get the pond.
If without pond, how can I?
All right, you have a point there. Without a pond, you cannot introduce it. Right? Maybe.
Then, Lordship.
So regarding 21 by 156 also.
That was not reflected in the input order.
Furthermore, a school building is situated. So the only reason you say is that it's a water body.
Only water body. But another part, Lordship, that was not nothing was considered.
So would you be happy if the lease is your prayer is truncated and 21 by 156 is only given to you? They may give both, but because this reasoning, yes, you are right. It may not be correct, may or may not be correct. We'll hear Mr. Dhar on that. So you say the entire representation was not considered. It's as if it's totally a water body, but by 156 is not a water body at all. Would not be a valid reason for rejection.
And also in plot number butter plot, already on the basis of the permission by the authority, I already constructed the some portion.
Well, yes, yes, Mr. Dhar. This reasoning is apparently not correct. Water body
may not be. But
we direct you to reconsider and if you think that you are
even DLLR,
the ground is not correct.
Kindly hear me. Even the present policy says DLLRO is not the authority. DLLRO is only the recommending authority. Ultimately, the cabinet will decide whether to grant. Well, that is the discretion of the state.
True. Let the DLLR, we can direct the DLLR to, we'll record our reasons because he is wanting a lease not only regarding only the water body, but also the embankment of that.
Embankment, without protecting the water body, we are not allowed to deal with the bank of the.
No, he's not wanting a conversion. He has already got a permission from the whoever Panchayat and all, Zilla Parishad. He has built a school there. He wants to introduce pisciculture. He wants a long-term lease for the entire property, 21 by 156 as well as 21. So you may have a discussion. You may reject the entire thing. You may give him just want to give him a long-term lease regarding the embankment only. And if you say it cannot be segregated, then you may decide on the entire thing. He's not wanting a conversion of the water body. He'll retain it as the water body. We'll make it very clear and have a reconsideration on that.
Now, kindly come to manual 272.
No manual with us.
273.
We don't have a manual. Everything is automatic here. Na manual na.
Yes, manual.
ল্যান্ড রিফর্মস একটা হলে তাতেই ম্যানুয়াল থাকবে ম্যানুয়াল আলাদা নাও পেতে পারে ও স্টেটের অ্যাপিয়ার করে বলে
পুরোটা বেস্টেড
কমন ল হাউসে ল্যান্ড রিফর্মস অ্যাক্ট ইয়েস হুইচ
flag mark also flag mark clause last person
right
kindly come to page 270
to
mode of settlement of fisheries Malad has got it
mode of settlement of fisheries yes. No, he's not wanting a fishery there. It's not a government fishery.
If the power,
it's a pond. It's not a fishery as yet.
Power is not with me to grant regarding the part vested. Yes, we have the power. Kindly come to page 2. Sorry, the rule 273. That is part vested. This tank is
only one thing. Lassi, I interrupt Lassi. My initial or rejection order, not the DLRO. The rejection order was additional secretary, government of West. This is the authority. Now, my learned senior friend.
That is that page?
Page 52. not rejected my PR of the DLLRO.
On the same ground.
Same thing.
Now, kindly come to 273.
Yes.
It deals with part vested tank. If a tank is partly vested, then Rayat can ask for the remaining land. If Rayat has 60% of a land, if a pond is about 5 acres, Rayat is owning amongst 5 acres, 3 acres of land.
If
Then
he owns at least 50%, then it will be maybe given to him.
Maybe given to. Now, my lord, kindly come to.
He is not retaining anything.
He is not retaining anything.
So this does not apply to him.
Now, kindly come to 272.
Yes. Government fisheries.
How my lord, this can be settled?
This is not a government fishery at all. It's a pond. It's a water body. Every water body is not a fishery.
Yes, true.
So these are not applicable. You are giving the ground.
Get a
If you come to page 52, let us see what your highest authority has
record of rights
cited by you of reason.
No, report lagani.
My lord, when my lord, he has not annexed the record of rights. My lord,
that will be decided by you, but the ground you have given is page 52 is the
yes.
Is
I've
additional
seen that.
statutory. Yes. Directed to reiterate in respect of
second paragraph.
As it is for water body, long-term settlement of a water body, same cannot be approved.
Approved as per
rule 272 to 273.
Yes.
272 will hold that 272 to 273 are not applicable here. Neither it is a fishery, not his wanting.
That exercise has to take place. Whether
A cardinal basis, the cardinal basis of this is wrong. Why you are saying this? 273 contemplates where a part is vested and a part is held by him in cash.
Yes.
Right?
Yes.
Part of the pond, 50 or more.
Yes.
Then the rest, obviously for obviously practical reasons, the rest may be considered to be given to him. He is not holding any portion of the property. It's vested in the state in its entirety. He has been given the right to settle. What is the nature of your right? To construct a school.
Construct the as per permission granted by the Panchayat.
Permission has been given to construct a school, whatever may be its validity or not. Now he is running a school on the embankment. He is wanting the rest of the pond. A long-term lease means he is admitting that it is vested in the state and the state is the owner. So neither 272 nor 273, because 273 does not come in. He is not the owner of any part of that pond. He is wanting a long-term lease, thereby admitting the ownership of the state. And it's not a fishery. So consider his representation on the correct yardsticks and then decide. Your rejection is only for that. This may be commercially viable to the state also, we don't know. You may consider a lease to be given, but on the right yardsticks. It's your discretion at the end of that. We'll hold that in our order also. But these grounds of rejection are not correct.
And you can supplement the reasoning.
No. Then, Mr. Dhar, why you are not doing that? We are telling you also that reason. The only reason of rejection is if conversion is not possible, these rules debar us. So you won't consider. So you do not open your mind to that consideration also. This is a pre-consideration rejection. So that is because we will be taking away that discretion from the state. State may, you and I don't know what the state will decide. The additional secretary may very well decide. You have never done that exercise. We'll ask you to do that exercise and then take your call. It will be your discussion. The conspectus of the matter is very short. The petitioner, in terms of applications made to different authorities, including the Panchayat Samiti, the Gram Panchayat, as well as the Zilla Parishad, has constructed a school on the embankment of a pond. Full stop. The embankment is situated in plot number 21 by 156, whereas the pond is situated in the adjacent plot number 21. Full stop. Next para. Learned Counsel for the petitioner submits that since the school run on the plot by the petitioner wants to introduce the subject of pisciculture in its curriculum, it applied for a long-term lease, both in respect of the school, both in respect of plot number 221 by 156, where the school is being run, as well as plot number 21, comprised of the pond. However, both the DL and LRO as well as the Additional Secretary to the Government of West Bengal have rejected such application, such request of the petitioner on the sole ground that grant of long-term settlement of a water body cannot be approved in view of rules 272 and 273 of the West Bengal Land and Land Reforms Manual 1991, and that no conversion of the water body was possible. Full stop. Next para. Learned counsel for the petitioner further points out that the learned tribunal refused to interfere with such exercise on the self-same ground that there is a clear embargo under rules 272 and 273 of the 1991 manual regarding conversion of water body. Push up next para. Learned counsel appearing for the state. What is your designation? Forgotten. Oh,
Only.
Learned senior counsel appearing for the state submits that the discretion is vested with the authorities to grant or not grant a long-term settlement in respect of the petitioner. Secondly, it is submitted that rules 272 and 273, read in conjunction, debar the long-term lease as sought by the petitioner from being given. Next para. However, we are unable to agree with the reasons given either by the Additional Secretary or by the DL and LRO or argued by the state for the rejection of the petitioner's application for long-term lease for the simple reason that neither Rule 272 nor Rule 273 of the 1991 manual are attracted to the facts of the case. Full stop. Rule 272 pertains to situations where government fisheries are sought to be settled with an individual, which are debarred under Rule 272. Full stop. Next para. On the other hand, Rule 273 speaks about part-vested tanks and considers a situation where the part of a tank stroke water body within bracket 50% or more bracket closed is already vested with a riot, the settlement of the rest of the pond with the said riot. Full stop. Next para. In the present case, the petitioner is not and does not claim to be the riot in respect of any part of the pond and stroke or the adjoining embankment, situated respectively on plots 21 and 21 by 156. Full stop. It is an admitted position that the land as well as the water body has vested in the state, which was the very premise of the petitioner applying before the state for grant of a long-term lease. Full stop. Hence, there is no scope of Rule 273 being applied. Full stop. Also, otherwise, it is nobody's case that the pond, that a government fishery is being run from the water body regarding which such long-term settlement has inter alia been sought. Full stop. Next para. Hence, the very premise of the rejection by both the Additional Secretary to the Government of West Bengal and the DL and LRO were palpably erroneous and perverse. Full stop. Next para. This court is fully aware of the discretion vested with the state either to consider the grant or non-grant of a long-term settlement of water body as per the petitioner's request. Full stop. Next para. However, in the present case, the rejection on the part of the respondent authorities was a pre-discretion rejection, in the sense that the respondent authorities did not consider the commercial viability or merits otherwise of the application of the petitioner to have a long-term settlement of the embankment and the pond at all, and rejected the same at the threshold, on the erroneous ground of bar of law. Full stop. Next para. Accordingly, the tribunal acted in a perverse manner in affirming such rejection on the grounds as indicated above. Full stop. Hence, WPLRT 130 of 2025 is allowed on contest, thereby setting aside the order dated November 13, 2024, as well as the impugned rejections by the Additional Secretary to the Government of West Bengal and the concerned DLLRO of the application of the petitioner to grant a long-term settlement of in respect of plot numbers 21 and 21 by 156 in favor of the petitioner. First up, the matter is reverted back to the respondent numbers. Which respondent should consider now? Both of you tell us.
Additional Secretary Lordship.
Additional Secretary is a party here?
Yes, yes.
So number 4?
2 Lordship.
4 is the Additional Secretary.
4 is Lordship. 4 is the Additional Secretary.
Yes, Mr. Dhar, should you keep it vague or the respondents?
No, the appropriate authority should have been the now, my lord, as per the present policy, my lord, the cabinet is to take the
Yes,
call.
cabinet
Couch in such a language.
Yes.
Thereby directing the respondent authorities to ensure that a fresh consideration is given to the application of the petitioner for grant of long-term settlement of lease in respect of plot numbers 21 and 21 by 156 by the appropriate authority in accordance with law. First up, we make it amply clear that the appropriate authority shall consider the said application on merits and take a decision thereon in accordance with law in writing. First up, such decision shall be intimated immediately to the petitioner. First up, the entire exercise as indicated above shall expectedly be concluded within 2 months. Within 2 months from
kindly make it 3 months.
3 months from date. First up, no address to cost. Thank you. এই বইটা ফেরত দিয়ে দেবেন আর কমন ল হাউস থেকে ল্যান্ড রিফর্মসের টেক্সটটা নেবেন। থ্যাংক ইউ।
পরেরটা কি কই আসছে না কেন বলো তো?
এগুলো সব অনিন্দিতা, এগুলো সব
আমি একা
হ্যাঁ প্রথমে করে দাও। জি the main writ petition is taken up for hearing along with the connected application আর প্রত্যেকটাতেই can such and such is accordingly দুটোতে হলো এরকম।
হ্যাঁ কোনটা পরেরটা?
Item number 8, I'm for the petition. By this petition, I'm paying only to prepone the date of hearing. Only to prepone the date of hearing, my lord.
Please use the microphone. Yes.
My lord, by this petition, I am paying, my lord, only to prepone the date fixed by the tribunal, my lord.
What is the date fixed by the
My lord, 9th December 2025. I have filed representation before the BLRO for the correction of record of right. Challenging inaction, my lord, filed the original application.
9th December?
Yes, my lord.
Why the tribunal is hard pressed or something? Tribunal is not functioning regularly?
Lordship, it's functioning, but the
Yes,
lots
functioning,
of cases are pending, Lordship.
This is the only prayer, my lord.
So we'll direct the it to be preponed.
Yes.
Within 2 months from the date of communication of this order. This is a simple consideration.
Lordship, can it be on 3 months, Lordship?
Can we do this? Can we just usurp the jurisdiction of the tribunal and pass the direction on the authority directly? And you give a reasonable time within which you have given a representation.
Yes, my lord.
Where is that representation?
Representation at page, my lord.
So why should they run from pillar to post? These are cultivators.
Page 21.
21. They'll again spend money, go to the tribunal.
21 is the original
This application is to be decided, right?
Not page
So this is the
50,
LRTT.
51 is the representation, my lord.
Pending the OA
Page
application,
51, my lord.
Pardon? Page 51, yes.
Yes, my lord.
So this representation shall have to be considered by the BLNL.
Yes, my lord.
Respondent number?
Respondent number, my lord.
4.
4.
Yes, we'll direct the BLNL to consider the representation within. What will be a reasonable time? Tell us. 3 months?
Sure.
3 months will be. In view of the innocuous nature of the writ petition, the same is taken up for hearing, along with the connected application. First up, there is no connected application.
No, my lord. No,
Along with the connected application, the writ petition is taken up for final disposal. First up, heard learned counsel for the petitioner and the state. First up, next para. The petitioner made a representation before the respondent number 4, block land and land reforms officer, Dhania Khali, for the purpose of correction of the records of rights in terms of the said representation. First up, the said representation being kept pending by the respondent number 4 for an inordinate period, OA number 1190 of 2025 within bracket LRTT bracket close was preferred before the West Bengal Land Reforms and Tenancy Tribunal, full stop. The fourth bench of the tribunal, comma, by the impugned order dated June 18, 2025, comma, postponed the matter for hearing till by fixing the next date on December 9, 2025. Full stop. Next para. It is surprising that for such a small prayer, comma, the tribunal has given a long date, comma, beyond almost 6 months after the initial date of hearing. Full stop. The innocuous prayer of the writ petitioner is merely for a consideration of the representation of the petitioner by the BLLRO within a limited period. Full stop. In fact, comma, the tribunal, comma, at the outset could have decided the issue. Full stop. Next para. In any event, comma, in the event the matter is relegated back to the tribunal, comma, it would be an unnecessary harassment on the part of the petitioner, comma, who is a cultivator by profession and need not run from pillar to post for such an innocuous prayer. Full stop. Hence, comma, WPLRT 131 of 2025 is disposed of by directing the respondent number 4, that is the Block Land and Land Reforms Officer, comma, Dhoniakhali, to consider and dispose of the representation dated March 3, 2025, given by the writ petitioner, comma, as annexed at page 51 of the present writ petition, comma, in accordance with law and upon giving due hearing to all concerned, comma, as expeditiously as possible, comma, preferably within 3 months from this date, on the basis of the server copy of this order, without insisting unnecessarily upon production of a certified copy for the purpose of compliance. Full stop. Next para. Accordingly, OA 1190 of 2025, bracket LRTT, pending before the fourth bench of the West Bengal Land Reforms and Tenancy Tribunal, is deemed to stand disposed of. No address to cause, urgent certificate. Prothome affidavit of service filed to be kept. Thank you. Give both of your names.
Next one is also same, my lord. Next date fixed on 23rd March.
Service.
Yes. My lord, yeah.
Appearing. So we'll pass the same order, same order.
My lord, it is, my lord, for the early disposal, my lord.
Yes.
Where is the order, impugned order?
My lord, last page.
Oh, yes.
23rd March 2026 date has been fixed.
It can be preponed, my lord.
And my lord,
we'll dispose of the OA itself and direct
lord,
you to
yes,
do it.
Representation, my lord, at page 89, my lord.
Representation, page 89.
Yes, my lord.
Private respondent,
no.
We'll bypass the WBLRT proceeding and like the previous matter, 3 months we are giving you. 3 months. Thank you very much for the fairness. Yes. Same BLLRO?
Yes, my lord.
He'll be abusing us today. Respondent 4 here also?
Yes, my lord.
In view of the innocuous nature of the prayer made, comma, we take up the writ petition itself for disposal, full stop. The petitioners made a representation for correction of records of rights before the respondent number 4, comma, namely that is the BL and LRO Dhoniakhali on March 3, 2025, full stop. The representation was kept pending, comma, being aggrieved by which the petitioners preferred OA number 1191 of 2025, bracket LRTT, before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. When the matter came up on June 18, 2025, before the first bench of the tribunal, comma, the matter was relegated to March 23, 2026 to be listed as a motion before the tribunal. Full stop. Next para. In view of the innocuous nature of the prayer made before the tribunal, comma, the tribunal ought to have decided the application on the very first day. Full stop. Next para. However, comma, since the petitioners are cultivators, comma, we do not want to relegate them back to the tribunal for such innocuous prayer, comma, thereby unnecessary compelling them to spend money and time, full stop, and run from pillar to post. Full stop. Next para. Accordingly, upon hearing learned counsel for the petitioners as well as the state, we state, WPLRT 132 of 2025 is disposed of by directing the respondent number 4, that is the Block Land and Land Reforms Officer Dhania Khali, to dispose of the representation dated March 3, 2025, given by the writ petitioners, annexed at page 89 of the present writ petition, in accordance with law, upon giving opportunity of hearing to all concerned, as expeditiously as possible, preferably within 3 months from this date. Full stop. Such the outcome of such consideration shall be intimated in writing to the petitioner at the earliest thereafter. Consequentially, OA number 1191 of 2025, bracketed LRTT, is stands disposed of. No orders to cause urgent certified copies. The parties shall act on the server copy of this order without insisting upon unnecessary production of a certified copy of the same. আচ্ছা আগেরটা না একটা লাইন অ্যাড করে দিও ওই যেটা লাস্টে বললাম যে রিজন অর্ডার সেন্টেন্সে লাস্টে বললাম যে ওইটাকে একটা সেন্টেন্স the tribunal, the respondent of 4, shall intimate the said decision in writing to the petitioner as expeditiously thereafter as possible.
Original application,
we have said consequentially that has been disposed. Stands disposed of.
Yes. That's how burden may be eased off.
Even from the and some fairness from the state we are getting in every matter. Now we are getting in every matter. So thank you for that also. Some fairness on the part of both parties would end this matter. Decide whatever is there and just pass on. Next. 10.
On the last day, Millard.
Yes.
I'm the respondent, husband, Millard. On the last day, Millard, I said, Millard, there were certain mistakes inadvertently crept in with the affidavit, which resulted in suppression of certain facts. Now, Millard, before these mistakes were pointed
in your affidavit in opposition?
Affidavit in opposition. So I sought for leave, Millard, to file supplementary affidavit. This was mentioned, Millard, before your lordship on 7/7/2025 order. Second paragraph. Learned counsel appearing for the respondent husband seeks to use a supplementary to affidavit of assets of the husband. Is granted a week's time. And Millard, the supplementary affidavit was affirmed. Before this mistake was pointed out.
They wanted to file a rejoinder to the supplementary.
Yes. And Millard, I have also prepared an affidavit to the application being can number 6, which states, Millard, that a proceeding under the BNS, Millard, section 295, corresponding to 340. Yes, Millard, because there was separation. I said, Millard, there is a bona fide mistake, and before they pointed out, I mentioned this, Millard, that there is a separation in a way. Even if Millard,
opposition, there is not much scope because court has to find a prima facie view. If you directive, you are seeking that leave to file an opposition, or you are given the leave?
No, I am seeking leave from Millard to use the opposition. I have prepared it. I will get it.
Mr. Chatterjee, even to form that prima facie opinion, let us have that opposition on record and we file a reply to that, so that we get the facts.
Because it's a matrimonial case, that is why I'm not opposing to it. But there is a specific judgment of the Honorable Supreme Court that here the court is the complainant.
Court is the complainant, but Mr. Chatterjee, we are aware of that. But court, there is no bar on the court seeking an affidavit.
That's a discretion.
That is what we told Mr. Basu, that he does not have a right to file an opposition, no hearing even at this stage. We are to hear you, see your application, not even hear you in a sense. So you are bringing to the notice of the court, we'll look into it, and if we find there is something, we'll direct an investigation, it will be taken care of there. Even for formation of that opinion, we are wanting an affidavit on record, so that to consider whether we should form that opinion or not. So we'll make that clear in our order also. Are you filing your rejoinder to the supplementary affidavit today?
Supplementary affidavit, Lordship, we were told on Thursday itself, and Friday there was a strike, so I couldn't get it formed. I have it ready with me.
So we'll extend that time for a week, and your reply to the opposition, you have given a copy of the opposition?
No, but I need to affirm, Millard. By tomorrow, I will affirm.
By tomorrow. So we'll give them 2 weeks then? Both the things? Yes. Supplementary affidavit filed by the respondent husband today be kept on record, full stop, on the prayer of the appellant wife, the time to file reply to the same, rejoinder to the same is extended till September 8, 2025. First up, learned counsel for the respondent husband seeks to use an affidavit in opposition to Can 6 of 2025, comma, which is in the nature of an allegation of perjury against the respondent. First up, learned counsel for the appellant wife rightly points out that the accused person in such an application is not entitled as a matter of right to file an opposition or even to be heard, and the court has to form a prima facie opinion as to whether an investigation should be directed upon lodging a complaint. For some next para, although we are fully conscious of the fact that the accused person in such a proceeding is not entitled as a matter of right to get a hearing, comma, let alone file an affidavit, comma, there is no embargo on the court to seek all facts to be brought on record before formulating even the prima facie opinion as contemplated under what is the new provision?
379.
No,
215 of the PNSS.
Section 215 as contemplated under section 200. Thank you. 215 of the BNSS. So for such purpose, comma, we direct the respondent husband to file an affidavit in opposition. First of, for the sake of propriety, comma, the appellant wife is also granted liberty to file a reply thereto, comma, also within a fortnight from date. Full stop. The affidavit in opposition shall be prepared, affirmed by tomorrow, and a copy thereof shall be served by tomorrow on the learned advocate for the appellant for such purpose. Full stop. The matter shall, both the applications shall be listed for hearing next on September 9, 2025.
Lordship, one thing, Lordship, is that the regular maintenance, Lordship, must be paid in every
They're not
month.
paying it.
After the application was filed, I have received arrears of nearly 6 lakhs. Lordship, kindly, Lordship can.
That is the entire arrears.
After that, 15,000 is still pending. Dues as dues.
Whatever are dues, will direct that to be deducted from the monthly income of the advocate for the wife.
Wife, husband.
For the respondent wife. You can also direct it to be credited to your account if you want.
Item number 11, my lord. This is first miscellaneous AP.
Right.
Application in connection with first miscellaneous AP.
Answer the appellant, my lord.
Against what?
Lord, after the admission, my lord, my learned friend has, being the respondent, taken out an application for vacating of that order.
What is the matter?
My lord, this is, my lord, after admission of a remand order.
Against what? What is the main suit?
Suit is for, my lord, declaration. That.
So then we don't have determination.
Yes, my lord,
that is what you. Learned counsel for both the parties rightly point out that this court does not have determination to take up this matter. So accordingly, let the matter go out of the list with liberty to the parties to mention before the appropriate bench for inclusion in the list. Next. Please give both of you, I mean, whoever is appearing with you and.
My lord, I appear for the respondent husband. I'm opposing.
They have not proposed yet. Let them propose the new law.
Lord, kindly see last order, 5th of August.
You have cured the defect.
Yes, I am on that, lordship. Kindly see the
20 rupee.
appeal of 2020, lordship. For the last 5 years, appellant is not taking any active steps to get it heard. Although I am ready to get it heard, lordship. Repeated directions have been followed.
Have you been paying alimony for all this time?
No, my lord.
Did you pay alimony?
My lord, during the pendency of the appeal.
Yes, appeal.
My client has paid thrice, 1 lakh each.
By court's order.
My lord, there was no specific direction for alimony. Not only that, they have not paid for any alimony.
Your alimony application was filed when?
Lord, this has been filed on July 25.
After
prior to that,
if you required alimony, you would have made an application before. After we waited for 5 years without alimony. Why should we be saddled from that day?
Kindly see page 8 of this application.
Yeah, you please take your seat. We'll hear him and then come back to you. Did you direct affidavits in this matter?
No.
Achha, not for the first time. Yes. Page 8, yes.
First of all, your lordship kindly see
8.
last order, 5th of August.
Right. Oh, by order of court. That.
Yes. Honorable Division Bench presided over my lord Mr. Somen Singh.
Oh, acha. But
There is a
there was no,
direction to pay.
but there
1
was
lakh.
no application for alimony on record.
No.
No. Maintenance
No.
application
No,
was
lordship.
that. Kindly see application for maintenance.
No formal application.
You
has
take
been-
your seat. Oh. Yes.
In the meantime, the respondent husband shall pay a sum of rupees 1 lakh to the wife.
No,
On
no.
5th of August order.
What were these can 1 and 2? Page 8, can 1 and 2, what were those? One was
That
for
is
stay.
earlier order, my lord.
This is against a divorce decree.
Yes,
Acha. Page 8, please come to page 8 of this application.
my lord.
Can 1 and can 2 are there in the cost title. What was can 1 and 2? Section 5 was there also.
Lord.
Order was either of these were alimony applications.
This alimony application was not there. For maintenance application was there. That is
What is the
pending.
difference between maintenance and alimony?
Sorry, my lord. Lord, if your lordships kindly see the last order, 5th August, there is a direction to pay 1 lakh,
We are on a more basic question.
my lord.
You had not filed an application for alimony even. How could the court direct this?
Lord, on thrice, on page 8,
We cannot pass orders beyond the prayer of the parties. That's a very settled proposition of law. Particularly whatever form money. Because a wife may choose not to file an application for alimony. She may not require alimony also. I have seen so many wives not applying for alimony because they earn money. They have their dignity.
your lordships kindly see page 12.
No, first let us complete
Your,
page 8.
your lordship's order. Kindly see page.
My order does not make it sacrosanct. Or our order. Let us come to page 8 first. If our order is wrong, that can also be wrong. Most of our orders are wrong, in fact. Please come to page 8.
Yes, my lord.
On the prayer of learned counsel for the respondent, the matter stand adjourned, right? The respondent shall in the meantime pay such and such. Affidavit of disclosure, you had filed this affidavit.
Yes. That has been filed. Both have filed.
So at best you could argue that even on verbal prayer, the court could because affidavits were directed. Rajneesh versus Neha. Yes. What was the interim order directed? 1 lakh? Only one time 1 lakh.
Page 10, your lordship. Thereafter, page 12, also 1 lakh. On the course, by court's order, they have paid. Not
Page
that they have
12, there is no 1 lakh.
Yes, my lord. Kindly see last portion.
Page 12? No.
Page 14, my lord. Last.
Say that.
Paragraph 8.
So time to time the matter has come up and you are getting 1 lakh.
My lord.
No, but which is all right with us. No, we had directed because there was a previous direction. They had not paid. They had not complied with the court order. We asked him. Your learned friend said he will pay during the course of the that he has paid.
That
Yes, lordship, we have paid.
So thrice they have paid
Yes.
1 lakh.
Yes.
Why are you not making the appeal prepared for hearing?
It is on
It's
process,
defective
my lord.
still.
Yes, on process, my lord.
What on
Every time they are making.
We cannot. Every time you are jumping up, we are stopping. Whenever we say something in favor of your client, if you jump up, then we'll leave it on you and you decide between yourselves and we'll just send you to mediation.
That mediation.
We can do that. Mediation has failed.
Mediation has failed.
For the same reasons.
No, my lord, they are not agree to pay total amount.
Might be for the same reasons also.
My lord,
Maybe your learned friend's client was inspired by his advocate to do the same thing before the mediator. But you have not paid you have kept the appeal defective. Why for so long? No, deficit court fees were filed.
Yes, we have filed.
So what about their appearing? So no question of service of notice.
Paper book is not made ready. We are preparing the paper book.
Preparing it quickly. They have already paid you 3 lakhs. So be satisfied with that.
Kindly comply with the orders dated 5th of August. They have not paid in terms of this order of this honorable court. 5th August.
That is annexed to the application.
No, my lord.
Our order.
5th of August.
Which
last
year?
order.
This year?
25. Honorable Division Bench of this honorable court on presided over my lord Mr. Somen Sen. 5th August.
কোথায় কি এক একটা
মানে-
অর্ডার এক এক রকম, একটা সামনের দিকে যাচ্ছে একটা পেছন দিকে যাচ্ছে। অর্ডার কতবার বলেছি একটু সাজিয়ে নিতে,
এটা যেদিন
ডিপার্টমেন্ট তো
একবার
করে না। আপনি have to pay.
Well, that
There's no option for you unless you challenge that order. You cannot argue that I'll not pay. This is an order of the court of a different bench, but it's an order of the High Court. You have to comply, sir.
certainly.
Either you have not filed an application for recall when you wait for the matter to come up when they seek an implementation, and you are saying that it's an order of the court. It may be a bad order, maybe an illegal order, erroneous order. Challenge it before the superior forum. If you want, we can give you legal aid for challenging before the superior forum. But unless there is a challenge, this order stands. You have to comply. It's an order of the court. You have to comply. You cannot come and complain every time the court is asking. Yes, thrice you have been directed, you have paid. Fourth time you have been directed, you have not preferred a challenge, you have not preferred a recall application, you have to pay. It's an order of the court, it's sacrosanct. All of us are bound by this. We cannot sit in judgment over a judgment passed by a coordinate bench. It's an order of the court, you have to pay. We can give you 1 month's time. Till that date, the appeal won't be heard.
Yes, Lord.
But we can fix the appeal for hearing. After that, we'll direct him to put in the paperbooks within that. We'll give you 1 month's time because of your father's ailment.
Yes, Lord. May I respect to Sabine one more thing?
Yes.
Let a time-bound direction may be given. Otherwise, this practice
No,
has
we'll
been going on
fix the
for
appeal
the
for
last
hearing
5
after the
years,
puja
Lord.
vacation.
Yes,
We'll
Lord.
direct them to put in the
Yes,
paperbooks within 4
Lord.
weeks. Yes. When the matter comes up for hearing, it is submitted by learned counsel for the appellant wife that the respondent husband has not yet complied with the order dated August 5, 2025, passed by a coordinate bench directing the respondent husband to pay a sum of rupees 1 lakh. For sub next para, learned counsel for the respondent husband submits that on every occasion when the matter is coming up before this court, different benches have been directing the respondent husband, each time, to pay a lump sum amount of rupees 1 lakh on ad hoc basis, full stop. This is the 4th such order, it is submitted, when such an amount has been directed to be paid by the respondent husband, full stop. It is pointed out that the respondent has complied with all the previous directions of the court to that effect, up to date paying a total amount of rupees 3 lakh. Full stop. Next para. Upon going through the records, we find that despite no application for alimony having been filed on the previous at the previous juncture, several orders have been passed by different benches directing the respondent husband to pay ad hoc amounts of rupees 1 lakh on each occasion, totaling to rupees 4 lakh till date. Full stop. Out of that, the respondent has already paid rupees 3 lakh. Full stop. Para. learned counsel for the respondent submits that he is equipped with necessary documents to show that after the order dated August 5, 2025 was passed, comma, directing the respondent husband to pay another tranche, 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 of rupees 1 lakh, comma, the respondent apostrophe's father was detected to have cancer and is now suffering, full stop. The huge costs of the treatment have prevented the respondent, comma, it is submitted, comma, from paying off the said last hyphen directed amount of rupees 1 lakh. Full stop. Next para, be that as it may, comma, in the absence of any recall application or challenge to the order dated August 5, 2025, comma, it is the incumbent duty of the respondent husband to pay the last installment of rupees 1 lakh on an ad hoc basis, comma, irrespective of the alimony application having been filed only in the year 2025. For the next para, however, comma, we are also of the opinion that the appellant wife cannot take advantage of the pendency of the appeal and not get it ready for hearing for a prolonged period on the one hand, and, comma, on the other, comma, getting advantage of different orders of the court on different occasions, directing the respondent husband to pay lump sum amounts of rupees 1 lakh. Full stop. Next para, thus, comma, to strike a balance, comma, we direct the pending applications to be listed for hearing along with the final hearing of the appeal itself in the monthly list of November 2025. Full stop. The appellant wife shall mandatorily prepare and file the requisite number of paper books within September 19, 2025 and serve a copy thereon on the learned advocate for the respondent husband. Full stop. Next para. The respondent husband shall positively pay the amount of rupees 1 lakh as directed vide order dated August 5, 2025 to the appellant wife within September 26, 2025. Full stop. Liberty to the appellant to mention the matter in the event such payment is not made by the respondent. This video হলো অসুবিধা না কোথাও আটকে গেলে ইয়ে করে না ঠিক আছে তাহলে বোল্ড করে ওই জায়গাটা ইয়ে গন্ডগোলের মনে হলে বোল্ড করে we're giving you about 1 week 1 month's time, exactly 1 month's time, and the appeal will come up in the month. This matter is over. Yes. D'accord.
In item number 13, Mr. Yusuf Diwan was appearing for the petition appellant, my lord.
Yes.
He's on his legs. He was here. He's on his legs before courtroom number 15, my lord. I'm praying for not to.
Do you know whether this copy, we direct this copy to be served of this application?
Not the copy.
এটাতে এটাই অর্ডার শিট, দেখুন তো এটা টোটাল অর্ডার শিট, আর কোনো অর্ডার নেই তো? ফার্স্ট এসছে তো?
Not informed, my lord.
We're directing to serve copy.
My lord.
His name will be recorded. He's in court. Is he in the court building?
My lord, yes, he is on his legs.
Give his name also, your name also, and his name also. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent, indicating that the application shall be listed for hearing on September 15, 2025, comma, when the appellant shall file an affidavit of service to that effect. Please serve copies of both the applications, file affidavit of service on 15.
My lord, item number 15 is also his matter, my lord.
This is item
13.
13. Let it be called on.
My lord.
Yes.
14, my lord, I am for the appellant, my lord.
Yes.
In pursuant to my lord's order.
Lordship, I am for the respondent. Lordship, I am
Here I
praying
appear.
for 1 week accommodation.
Why?
Lordship, I don't have the brief because the client has not yet reached court with the brief and wakalatnama.
Why 1 week? Client will take 1 week to reach court.
I need to study a bit.
Yes, what do you say?
Yes, yes. But my lord, kindly record that service is complete because status report I don't have.
Have you filed wakalatnama?
No, Lordship.
You will be in difficulty.
Next.
What is your name?
Devojyoti De.
Devojyoti Das. De. You will be filing the wakalatnama. We will record your name that you have instruction to appear.
My junior will be there.
She will be appearing. What is her name? Ananya Chakraborty. Mr. At the time of call, comma, Mr. Devojyoti Das, comma, Mr. Devojyoti De, comma, along with Ms. Ananya Chakraborty, submit that they have instruction to appear on behalf of the respondent. The respondent seeks a week apostrophe S accommodation. Upon hearing learned counsel for the appellant and the respondent, comma, the matter is adjourned till September 2, 2025, when it will be listed next for hearing under the same heading. Leave is granted to the advocates appearing for learned advocates appearing for the respondent to file their wakalatnama in the meantime.
Good.
My lord, item number 13, my lord, I have just found the affidavit of service. Item number 13 has also been served and 15 also. Both have been served, my lord.
13 এ যেটা অর্ডার তুমি রেকর্ড করলে আছে ওটাতে affidavit of service filed to be kept on record প্রথমেই করে নাও।
But so far as 15 is concerned, my lord, I appear for the respondents, my lord.
What is the application? Section 5?
Section 5, my lord, and injunction, my lord, I want to file an affidavit, my lord. Affidavit in opposition.
No, in the section 5, what is the number? Can 2. What is the delay?
104 days delay.
204. You want to use an opposition. Learned counsel for the respondent seeks to use an affidavit in opposition to TO2 Can 2 of 2025. Full stop. Accordingly, file it within a week, Mr. Shen. We'll do this side of section 5. You are lucky we are granting you permission to
2 weeks, 2 weeks. My lord, one certified copy is to be obtained from the trial court. That is the reason. That is
Very
the
well.
reason.
Accordingly, the respondent is directed to file his affidavit in opposition to Can 2 of 2025 within September 8, 2025. Stop. Reply, if any, shall be filed by September 15, 2025. The applications shall be listed for hearing on September 16, 2025. Affidavit of service filed to be kept on record. আর ওই 13 এর affidavit of service filed today ওটা শুধু Yes, Mr.
My lord, kindly come to my lord's judgment. My lord, I find a review application. My lord, why my lord, it will be allowed or not, that is up to my lord's discretion. My lord, kindly see my lord, there are two appeals. My lord, may I just
yes,
my lord say surmise point of fact. My lord, only thing, my lord, two appeals were being preferred First, the appeal preferred by the state challenging the order passed in a acquisition judge. Order passed in a acquisition case passed by the learned acquisition judge, but in terms of reference, section 18. And my lord, they filed an application for cross objection in connection with my appeal. So my lord's order actually allowed their the cross objection while dismissing our appeal. That is challenging the order of the learned judge passed in a reference case. Not kindly see, my lord's order was on the basis, only on the basis, core issue was that since it is a void one because
lapsed.
2 years, yes, section 4, because fact is 3.1 and 4.1a of Act 2 was invoked, but award was passed after 2 years. That's little bit time have elapsed. So my lord held that is a void one. So the appeal was dismissed. So far, my applicant, their appeal was allowed.
Mr. Sengupta, please give us half a minute. We'll come back to you. According to as far as our recollection goes, you took 2 points. One is that this Act 2 acquisition cannot lapse.
Yes.
Second is that this point was taken for the first time in this appeal, which could not be taken.
Reference case. In the reference case, no point was taken.
Very. So for the taken for the first time in this court.
In this court.
These were the 2 points you were arguing. So you can elaborate on that.
Yes, then my lord, kindly to my lord, the first my lord, the point, my lord,
judgments you are citing, they did not have any copy. That's why I asked you to circulate. Yes, we requested you to do that. Yes.
My lord, first point, my lord, I am arguing that my lord knows, my lord, I should not say why, unless there is an patent error on the face of the records.
Yes.
Because error is apparent. My lord need not go into the evidence.
Right.
Or any facts. My lord, here the point is first I am referring that, my lord, I am covered by, my lord, the order 41 rule 22 explanation. It is clear that if the point, yes, was not taken even in the first instance, but evidence was laid down, but issue was not raised, or whether raised or not, that is not material, but evidence was taken into account. But my lord, in that circumstances, my lord can take note of in the appeal. But in the facts, my lord, in the reference case, only they are aggrieved because due to that the money, compensation money which was paid to, which was passed by the district magistrate, it is, my lord, not sufficient. So they have sought for, my lord knows that.
Mr. Sengupta, no further fact was required to be gone into for coming to this adjudication.
Yes.
That point was not taken.
No evidence. Point was not taken.
Acha. Now, you please deal with Order 41 Rule 33 also of the Code of Civil Procedure. Because that is one question we put to you on the last.
I know that. I know that.
Obviously, you know Order 41.
I know that, my lord.
All of you know.
Because I have
nothing new. Because
no, my lord, I have come from the civil background. My lord knows that, and my lord, this is no. So for interpretation, unless the person advocate,
the court is not debarred from passing any order or further decree.
Yes. My lord need not go into the anything. Only my lord will see yes whether point was taken or not. If the point or some evidence was taken regarding the
even if point was not taken, let us.
My lord, if it is, my lord, kindly consider 2 things.
We are taking only on that.
My lord, kindly come to first Order 41 Rule 22.
Yes, 22. Yes, absolutely.
Yes, cause objection, my lord,
right.
A respondent aggrieved by a finding of the court in the judgment on which the decree appealed against is based, may, under this rule, file cross objection in respect of the decree.
No, you are filing what? Reading what? Order 41 Rule 22.
Order 41 Rule 22 explanation.
Oh, explanation directly.
Yes. Direct. Because Malad knows that cross objection.
Yes. A respondent aggrieved by a finding of court.
Respondent aggrieved by a finding of the court in the judgment on which the decree appealed against is based, may, under this rule, file cross objection in respect of the decree insofar as it is based on that finding. notwithstanding that by reason of the decision of the court or any other finding, which is sufficient for the decision of the suit, the decree is wholly or in part in favor of that reason. So there are two things. My lord, no, I need not discuss.
No, please.
That law.
No, please.
My lord, unless, my lord, first, whether pleadings was there or not in the reference case. Admitted fact, no pleadings in the reference case, only for enhancement. No pleadings. And since there is no pleadings, even no evidence or any discussion was made in the reference case, my lord, while passing the judgment in his favor. That is in section 18.
Right.
So, my lord, kindly see, my lord says, first, for the first time, my lord knows, my lord can take this point, Mr. Sengupta, there are other provisions, section, my lord, 107, my lord knows, my lord can say that. But, my lord, only thing, my lord, what I am harping, my lord, subject to my lord's again kind approval, my lord, that these things, my lord, probably, my lord, cannot be acted again at the first appeal court. My lord, on that basis, my lord, I am referring, my lord, the judgment. My lord, first, my lord, one after another. The judgment. Yes. My lord, this is, my lord, this is reportable judgment. This is the latest one regarding, my lord, I have handed over, my lord, kindly, just a minute, my lord. This is specially petition civil appeal number that is passed by, my lord, in
Manohar's case.
Kishundev Raut versus Govinda Rao.
Oh, acha. Acha, Krishnadev.
Yes.
Yes.
My lord, this is a fact in a nutshell, my lord. It was discussed that for the first time, there was no pleading in the plaint. For the first time, they have, my lord, taken a point regarding adverse position.
Need law be pleaded in the plaint?
No, law not. Adverse position is a fact.
No, adverse position.
No. What I am, so far in this case.
Their adverse position. In your case.
In my case, no.
It's a pure question of law.
No,
whether
it is not a pure question of subject to Mallard's approval.
You are saying it's a mixed question.
Yes, mixed question of fact and law. Mallard, like adverse position. Mallard knows that. Adverse position is pure question of fact. Me are saying will not do. How your position is in adverse to the owner.
But the dates disputed in this case, in our case, your case.
No, nothing is not. Why I am citing
the dates are, if the dates are not disputed, when the notice was issued and when it lapsed, is a matter of arithmetical calculation.
Second point. Malad, I am on the point.
No, then it's a pure question of law.
This is
on the basis of the fact.
First, Malad, let me place my Malad. So far, first point is concerned, because there is no pleading. So far, the decree which was the acquisition proceedings stood lapsed since the award was passed after the specific period of time. So there is no acquisition proceeding. This is a void one. First point, my lord, I am making, my lord, in a review application, my lord, first point, my lord, that I could have understood that point was taken in the reference case, but it was not argued or it is there. And even no evidence was taken, even in that case.
But in the appeal, even in a second appeal, cannot a pure question of law be argued?
Pure question of law, only, my lord.
Here it's only
without jurisdiction. Yes, my lord. I can say it is without jurisdiction. Yeah,
it would be rendered without jurisdiction because if that is lapsed.
That I am citing, my lord. Even in a review cases, my lord, judgment is there. My lord, it was not aware. My lord, I don't.
No, that's a different thing.
My lord, yes. Even in that case, review is not applicable when, well, I just put that when, after passing
of... the review is not applicable. We are going one step back. Yes. We are speaking about our judgment which is under review.
Yes.
That judgment was rendered on the basis of facts which are already on record. Yes. The dates of notices were admitted. There was no dispute on that.
No, that is fact, my lord.
The date of notice is known to us. And if it is found, it is argued in that appeal for the first time.
Yes.
And if we find from an arithmetical calculation that as per the law, this is the time limit, this is the admitted date of notice, and it lapsed on such and such date by operation of law. Yes. This is a pure question of law, Mr.
No, my lord, subject to my lord.
Need it to be pleaded? Can law be pleaded in a plaint?
No, if no evidence is pleaded. Required to be.
Law is also not.
Law is also not required to be pleaded. But my lord, here, my lord, there is a question, my lord.
Yes.
My lord, there is a fine distinction between the, my lord, the without jurisdiction, and there is a pure question of law and a mixed question of fact and law. Mixed question of fact and law is also a law. Well, lord, according to latest Supreme Court.
Mixed question, maybe there is
fact
some doubt whether the court can without.
Supreme Court, there are divergent of opinion.
Mixed question will take the view in your favor.
Yes.
We say that if it's a mixed question, there is an element of fact.
Yes.
Should have been argued. If not argued in the trial court,
If there is no pleading, my lord, then my lord,
yes.
have a case.
Yes.
That's the thing, my lord.
If a question of fact is involved.
First point is concerned, my lord, that is absolutely on the basis.
This is why are you citing this? This is from adverse person in a second appeal.
Why I am citing
second appeal adverse person can it be taken for the first time?
Second appeal, in the second appeal, first appeal, my lord, that point was not allowed. In the second appeal, it was allowed. In the Supreme Court, no. My lord, only why Supreme Court has, my lord, kindly come to page, my lord, only thing, my lord, I am sure it is based on the, my lord, the Privy Council judgment. My lord, kindly consider.
How can 7. This is very palpable, Mr. Sengupta. We don't require a Supreme Court judgment for this proposition that a question of adverse person cannot be taken for the first time in second appeal. This is very basic.
Adverse is a, my lord, question of fact and law. Well, this is my limited knowledge. Adverse
position. It's a pure question of fact, in fact.
Pure, no. Man, this is also a law.
Everywhere law is involved.
Man, yes, man, but
when you go for Jamai Shoshti to in-laws, that there's some law.
If I not plead that, man,
adverse person is pure question of fact.
Yes, whether, no.
Why are you citing this judgment? This says in second appeal for the first time, adverse person plea cannot be taken.
Yes,
because it's very obvious. It's very basic.
Basic thing, my lord.
Citing judgments for this.
No, my lord. Why I am saying, my lord, that my lord knows that I am just reading, my lord, paragraph 22, my lord, I am just reading page 12. My lord, based on this, that plea of adverse person raised for the first time in appeal before the Privy Council. Their lordship felt that since there was no allegation of adverse person in the plaint, no issue raised as to before the court below that could not entertain the plea. Then paragraph 23. Just I am said that I am reading, my lord. On the basis of that, this judgment, my lord, was delivered. Is another case in which the paragraph 23, in which the same principle was laid down, also see Sasan Saj. Next 24. It is important to remember basic rule of law of the pleadings. Basic rule of law that my lord knows that this is a pure is that party can only.
His lordship doesn't know that we know.
According to which he has alleged and proved otherwise on the principle of secondary allegata probata, a party is not allowed to succeed where he has not set up the case which he wants to succeed.
It hits the senses. If someone says second appeal, in the second appeal, adverse person can be taken for the first.
Yes, my lord. First appeal it was discarded, second appeal it was allowed. So far this case
cannot be taken for the
yes. Now, my lord, my question, my lord, my limited. This is my lord, the whether this is a fit case for granting or for passing any order in my review application. My lord was in the view, my lord made an observation, Mr. Sengupta, whether it is a pure question of fact and law or is a pure question of law. My lord, in that case, even if it is assuming, but it is not a pure question of fact and law, but is a pure question of law.
Yes.
In that case, my lord, the judgment of this our High Court, my lord, kindly see the 12/4/2022. Because in a review application, it was passed on in the year 12.
Which judgment?
That is MAT 1545 of 20.
What is the name of the parties? You have not cited that.
Is State of West Bengal, because state has.
No. That you have not. You have given Kishundev Raut, Sadhon Rai, and Monohar.
After that, I have handed over my clerk. My lord, I am here.
Your clerk handed over to whom?
To my lord's officer, my lord.
Generally, we cite judgments before judges. And advocates do that.
No, my lord, after because I have to, because it has Xerox.
Your clerk handed over to my officer, then let my officer decide. Generally, Mr. Sengupta, advocates cite judgments before judges.
Hey, my lord, I have cited.
It's a new precedent that clerks cite judgment to court officers and they decide.
Kindly have one at
No judgment was handed over to our officer. If it was handed over, it would be given to us. Yes, this is a new judgment. Oh, this is not a judgment.
Yes.
not a judgment. No point of law has been decided.
Well, kindly see the ratio is there.
What ratio? In an attitude?
Kindly see. The
An
ratio is
intellect-
there. It
Yes,
is
let
not
us see.
initiated
Let us see the ratio. Yes.
Yes. Well, sorry, my lord, I am.
This must be there somewhere. We saw it somewhere. Yes, yes, we have it. What we couldn't imagine is that this is a judgment you had cited.
Yes, judgment of this honorable court. Well, because the set aside order of the single judge was set aside because it was.
Yes, yes. Cite it, which portion?
But fact remains here, my lord, sorry.
This is for what proposition, Mr. Salim?
That the
Yes.
acquisition proceeding didn't lapse. Even if the award was not passed within the even if there, the facts award was not even passed.
Just read the relevant portion. Yes.
This is very concise, but fully loaded with reasons.
Yes.
Ratio is, my lord, is there.
Page 2, the last paragraph.
Yes, we have heard the learned. My lord, kindly see. My lord,
Page 2, last paragraph.
Page 3, the page 2 last paragraph.
Page 2, yes. We have heard the learned counsel that the order of the learned single judge cannot be sustained since the acquisition of land in question was initiated because 418 under Act 2, my lord, the 24 of the 2013 Act is clear. If it is not initiated under the Act 1, then, my lord, the 24 is not applicable in terms of Section 23 or 13 Act. Hence, Section 24 or 26 cannot inure to the benefit of
this
the
is on a different book. 2013 Act cannot apply.
Yes.
Right to Fair Compensation Act, that will not apply.
That the fact.
This is not on the point that proceeding will not lapse.
That proceeding is, that's why, my lord, that proceeding would not lapse, then there is no question of voidness.
The question which has fallen now before us was not either argued or decided in this case.
It was argued. Well, kindly see.
We don't find a line of argument. Where is it decided that whether a proceeding would lapse?
However, the writ petitioner must receive the compensation in terms of Act 1 of 1894.
Yes.
It appears from the order into amount of rupees has been determined as compensation. Learned LA collector is directed to pass an award taking into consideration said amount of 11 lakh such and such within 4 years. If the said sum does not include solicitation such and such company award figures as envisaged in the 1894 Act. Thereafter, the LA collector shall follow the procedure in land acquisition 18 by giving due intimation to the division then entitled to take further steps in terms of land acquisition, whether under Section 18 or no further order, and stand which is quashed accordingly.
That is precisely what was done in your case.
Yes, because kindly consider 41A was invoked. Award 41A, once 41A was invoked, that is vested. Because, my lord, in 9.3, if my lord sees that the incomplete proceeding, my lord, this is a incomplete proceeding was converted into a complete proceeding by exercising power under Section 9.3b. That power is in the Amendment Act, though Act 2 expires due to his term, that is 31st March 1997. That in the meantime, the amendment in 1894 has come forward. That is 9.3a, where Section 41A was not issued, then 9.3a. And when 41A was issued, 9.3b. So, my lord, the vesting in the 9.3b, my lord sees the word in the 9.3b Acquisition Act. There it is clearly said that vesting has already been taken place. Kindly see, my lord, Land Acquisition Act, kindly say, just read, my lord, 9.3b. My lord, I think, my lord, I'll be clear to my lord. The vesting, which was even if, my lord, otherwise, legislature on its own, in his wisdom, think fit that the acquisition didn't lapse, you can extend it. Why? For which legislature has rightly incorporated that in the 9.3b, because here 4.1a was invoked.
Act 2 question.
First 9.3a it is in the 9.3b. Kindly see, because here 4.1a was invoked, that's why 9.3b.
Right.
Kindly see each word.
Yes.
The legislative intention is clear that the acquisition didn't lapse. Sorry.
What shall we read?
My lord, 9(3)(b), my lord, kindly see. My lord, বইটা নিয়ে আসিসনি? আরে তোরা না খালি
Must have it by heart. That's why he has not brought.
Yes, my lord. একটা বই নিয়ে চল। Can record. My lord, kindly see, provided, kindly see that এই একটা বই আছে। Now, this case will come up before my lord again, my lord, in another case because I prepared another. Will come up on them. My lord will may vary or they, my lord, not, if my lord doesn't agree, my lord, that should be referred to the
No, that's different.
Division. Which has already been, my lord, vested. Kindly see that word is there.
The possession whereof has already been taken on requisition and notice for acquisition has also been published.
No, then, my lord, provided, which had already been vested. Well, kindly see that that sentence was there.
Yes, last proviso.
Yes.
Collector.
That the legislature intention is clear. No lapse. My lord, I will hear this matter because in another appeal, my lord, I took this point, my lord will hear that.
Only for the purpose of due compensation to the persons interested has
and this is in the 1894. But language is clearly stated, which had already been vested. So section 4.1, even if it was issued at the point section 4.1 was issued, time is not the factor. Otherwise, there would be no occasion to legislate in that field.
Upon the collector taking possession, already vested,
already
absolutely
vested, yes.
in the government, free
Yes.
from all.
So already vested has been incorporated in that 9(3)(b). So acquisition didn't lapse. Well, this is my humble submission, subject to my lord's kind approval.
All right.
So my lord, this point, my lord, kindly consider one thing. In review application, I did not cite this judgment, even if this judgment did not cite, or my lord has got no occasion to go into that.
No,
my lord, that
for this,
doesn't
no
mean-
evidence
yes,
appreciation is necessary.
If the judgment, if it's passed after my lord's, then no review. Suppose any judgment has come up, my lord, is this absolutely clear, my lord?
The law was settled,
Settled
on that date itself.
Yes, sir.
Good. And the statute is clear. This is a statutory interpretation. This statute was there when we passed our judgment. So then probably review, it's a review case.
This is my question. And my lord, probably, because I came to understand, my lord, subject to my lord's learned friends, my lord, submission, that there is an understanding because yes, they have no, they will not challenge. That is the instruction I have got. I subject to my lord's, my senior advocates, my lord, that they will not challenge regarding that quashing, that may be allowed. But my lord,
He gave
they are
several
saying-
options. Your
Yes.
friend gave several
Yes,
options
yes.
to the
They are saying,
but that was by way of argument, no
yes,
undertaking given
that's
by
my argument. But they are
no understanding or undertaking by
Yes,
anybody.
yes, yes. No.
Mr. Bera gave several options to the court in
Yes,
law.
yes. He has given so much options. Yes.
Point which is sought to be
No, what about the other judgments? Don't take your seat so early. Oh, we won't permit you to.
My lord, other judgment, my lord, because
Monohar and others and others.
because others judgment.
This is on review.
My lord, yes.
No, Monohar is on something else. How compensate?
No. Monohar, because my lord has dismissed my appeal because I cannot, because unless appeal be restored, then I can cite this judgment. Because how the compensation is to be assessed, whether the compensation was an excessive one or it has to be come between the award
And you also
compensation and the enhancement.
cited another judgment, Justice Arijit Banerjee's division.
Oh, that is the my lord, review.
Review,
My lord knows that, my lord, the point was taken because it is the mother judgment of the, my lord, though I should have taken the name, but I have to take the name, my lord, the then Honorable Justice, the presided division bench, or the Honorable Justice, the Honorable Justice, my lord. My lord, kindly consider one thing, that judgment, my lord, I am on the point, kindly see.
High Court can pass orders ex
Yes,
debito justice.
because my lord has got, even if suppose
Your
I
application
didn't,
is barred by limitation.
yes, but no limit is there is few days, my lord.
No. Did you condone the delay?
No.
Have you given any explanation?
Yes,
IWASH must be given.
No. I have given the explanation in my stay application. In my stay application.
Stay application, you have given explanation for the delay.
My lord, what is there?
What is the delay about?
About, my lord,
only 4 years or something.
No, 4 years not, my lord. My lord's order is, my lord. That
No. What is the delay?
Delay, my lord. My lord's order was
some
passed.
Days or some months or what?
Months. My lord's order, kindly see, my lord's order was passed.
You should put in a formal application.
Yes, formal application. My lord's order was delivered on, my lord, 30th 4th 2025. And this review within 2 weeks, within 2 months. My lord, kindly consider one thing. This is the point which I will take after if I win, subject to.
Then we'll
my lord, that assessment whether it was excessive one or it is right one.
Right. Yes. Yes, Mr.
Yes, my lord. On this point of vesting, my learned friend has not stated anything.
No, lapse only on whether it could have lapsed.
Only on the point of vesting 9(3)(b), your lordship has said that the property stood vested in this state. My lord, after that, 9(3), my lord, the 11A was incorporated, where it has been kindly see after 9(3)(b), 11A in its application to state of West Bengal. It is irrespective of vesting. 11A. Just a minute. We want
to know. I am not. 11A is not applicable.
No, let him finish.
11 because I didn't, because 11 is not applicable.
11A
He did not
is
do
not
this.
applicable, he is saying. 11A, kindly read, amended in West Bengal.
Yes.
The award must be declared within 2 years from the date of publication of notice under section 3, on the basis of which your lordship has declared that this proceedings to lapse by operation of law, that the award was passed beyond the statutory period of 2 years. Has your lordship got it? West Bengal amendment. On the basis of that, your lordship has directed that the proceedings to lapse, the award is bad in law.
And proviso incorporated in West Bengal is provided further that in respect of acquisition of land referred to in subsection 3A and subsection 3B, specifically referred.
Specifically.
The award shall be made within a period of 2 years from the date of the issue of public notice. And 11A, the primary portion says, the main body of the section, the collector shall make an award.
Second is in
Lapse.
respect of land acquisition.
So by virtue of this West Bengal proviso, that lapsing has been corresponded with 3.
After 9(3)(b). So, my lord, there is no question of continuation of vesting after lapsing. But not only that, my lord, by this judgment, I think possibly this judgment has been changed subsequently. The judgment of my lord, Mr. Justice Orijit Banerjee, sitting with my lord, Mr. Justice.
Yes.
My lord,
This order has been modified.
Now, my lord, what has not been stated that he is saying vesting is absolute. Once vested, it cannot be divested. That is not the law. In 2002, that first proviso to 9(3)(b), your lordships kindly for a moment see once again 9(3)(b) first proviso. Has your lordships got it? Provided that the date of notice under section 4(1)(a) shall be the date of computation of the compensation. If I am not wrong.
Yes.
Number the proviso of this. Virus of this proviso was challenged in 2002, immediately after Land Acquisition West Bengal Amendment Act 1997 came into operation. But this judgment, this virus, it has been held in that judgment, that is Savitri judgment 2002 CHN, possibly I could not, because I am not, I have not brought all those decisions where a distinction has been made under vesting under Land Acquisition Act and vesting under Act 2 of 1948, 4(1)(a). There it has been clearly held that so far as the Land Acquisition Act is concerned, vesting is absolute. There, once property vested, there cannot be divested. But in Savitri Devi's case, it has been held that Land Acquisition, so far as Act 2 is concerned, once the notice goes, vesting goes. Vesting did not survive. And that was ultimately because of difference of opinion, that was referred to larger bench, just headed by, presided by Mr. Justice Bhaskar Bhattacharya. Therein it has been, that judgment has been upheld
of Justice Dilip Kumar.
Just give us the citations.
Today I have not brought all those citations.
We'll put it as to be mentioned tomorrow. Give us the judgments. Just the citations.
Yes, not
So that
only that,
Mr. Sengupta can reply to.
yes, not only that, vesting goes, that went up to Supreme Court. Justice Seth's judgment has been upheld. Then in another case, the same point went up to Supreme Court. There it has been held, the division bench of this court held in Mandodari Bhaka's case, that once the notice goes, vesting goes, property returns back to the landowner. That was challenged in Supreme Court, it has been upheld. So, this concept of vesting which is sought to be argued, that is not the case. Because I was not ready, I am ready, fully ready, because I argued this case so many times, so far at bench. And I have been able to succeed by always that this judgment has been upheld up to this. That once the 4-1A notice goes, everything goes. Even the latest judgment of, very latest judgment of Justice Bosak, that has been also upheld. All this, all the your lordship.
Just bring the judgments tomorrow. We'll keep it tomorrow. As Pathat tomorrow.
Pathat tomorrow, your lordship.
My lord, only thing, my lord, if my lord
I can, one more day I can go to
day after tomorrow. Day after tomorrow.
Because I have to.
Yes, yes.
Photocopies of that one day I may not.
Day after tomorrow, Mr. Bera, and please intimate to Mr. Sengupta in advance what would be the judgment. Why did you suppress?
Because my lord, Dhavitri's case, it is not a suppression, because it is not applicable. Because
suppression not only says suppression of material law.
He is relying on his parliamentarian, which went up to Supreme Court, which has been upheld by the special bench. Always where he faced, he is
doctrine of merger is by this window.
Yes,
Special
Supreme Court said.
Not appeal.
That is not merger. But larger bench, he says larger.
He doesn't know.
He doesn't.
Sorry to say. Because I could have.
He doesn't know and doesn't know that he doesn't know.
Yes.
So on two levels.
That is the three-man budget.
Let us see whether you know or you don't know that you don't know what.
Yes, let them place fellow Supreme Court judgment. SLP was dismissed.
SLP upheld the judgment. Said they are the award.
So
that is merger.
Well, no, that is not the merger.
This is one of the few things we know.
Well, it is the three-man budget.
Other judgments, so many judgments. I can supply copies of all those judgments with the only on the point of vesting. That vesting did not continue. Vesting did not continue.
Well, I want that.
So, my lord, no apparent error on the face of the record.
Mr. Mitra, since Mr. Sengupta knows, you need not refer to him the judgments in before that. But Mr. Sengupta, since you say you know, we won't give you further time to give reply. You'll have to reply then and there.
Yes. My lord, I will. Yes, I will.
One thing I may.
And my lord, kindly, I will refer. My lord,
just a minute. Sentence.
You won't refer to anything else. You have referred to whatever you did.
My lord, if your lordship so wants, I can supply the judgment with short notes. Otherwise, only I can give him the reference. What your lordship pleases.
Your point is this: you are most primarily relying on section 11, the amendment.
Yes.
West Bengal Amendment 1. Second is that this 9(3)(b) also you say this line of judgment in Savitri Devi and larger bench. Supreme Court, where for the time being, as Mr. Sengupta says, SLP dismissal is not merger. So up to larger bench. And also Mandodari's judgment and Justice Bosak's judgment.
Yes.
You can
yes.
You can give a half-page bullet point note. Just 2 points that just refer to section 11 and 9.
11A is not on that. It is only on
11 is your argument. Just your argument that
it is on the point of continuation of vesting.
Yes.
It is only on the point of continuation.
You need not file any written notes also. You can just file the compilation of judgments.
Very
the major judgments only, 4 or 5 judgments, whichever you feel are most important.
Very.
Thank you.
Another judgment I have already handed over because so many submissions.
You have relied on 2 judgments.
Even Haryana State, my lord, industrial, my lord, I will rely upon that because
your argument is finished. Now he has replied.
No, my lord, I have handed over.
You cannot just spring up judgments as surprises. You have cited 3 judgments, Mr. Sengupta. One is this judgment, Justice Banerjee's judgment, this 2-page judgment, Kishon Deo Raut, and Sadhan Rai. These are the 3 judgments you have cited.
I am citing 2000.
Where is that? You have got a copy?
Haryana State Industry Investor. I will hand over.
2000?
Just a minute, my lord. Just a minute. Yes, my lord. That is 2023 6 SCC 512. My lord, here.
What is the name of
that
the
is
party?
Three-man bench judgment.
Name of the party. Name of the
Name of the party, Haryana State Industrial
Right.
and Infrastructure Development. Well, this is a point. But I just have only just.
What is the paragraph? What is the paragraph? You cited today itself.
This has been
distributed in subsequent judgment. Why all those things are?
So he's formally relying. Yes. Yes. Which paragraph, Mr. Shen?
Paragraph, my lord, so many paragraphs, my lord. Because, my lord, these points.
So many paragraphs.
My lord, because.
Which are the so many paragraphs you're relying?
Only just I am taking a half a minute. Well, here the point was taken.
It will never be
That-
ended.
Yes, yes, complete.
That, my lord, whether after coming into force of 2013 Act, that is January 4th, 2013, whether if any acquisition proceeding initiated under Act 1 by invoking power under Section 4.1 of Act 1, not Act 2, whether the authority can proceed with the same by issuing Section 6, Section 7, Section 9, and Section, that is the position. Although position was already been taken, then they can issue. Even if that act was not.
No, that is what is generally done.
Yes.
If it's an Act 1 proceeding,
Yes.
then compensation is given under the new Act, but the acquisition proceedings under the old Act.
Old Act.
That is what is standard. That is standard. That is
Yes,
standard.
no, there was no, and
There is no dispute on that.
There
The
is no
dispute is whether the proceeding itself lapsed.
Yes,
If it's not it's a non-lapsed proceeding, it's a surviving proceeding, then current compensation payable,
yes, yes.
but acquisition
Whether
proceeding under the
vesting
previous.
or not, that is a question my lord will decide.
That has not been held in
Whether-
Haryana state is not a proposition for that regarding lapsing.
No,
It's on a different.
yes, that's it.
24 has
Because-
no application in this case.
Because in Haryana's case, three-man bench judgment,
Everything
after
is
that,
taking complete.
স্যার আমাকে একটু বলতে দিন।
আরে আগেই তো বলবেন আপনি।
না আগে বলিনি, কোন পয়েন্ট ওয়াজ নট টেকেন বাই ইউ। তুমি আপনি বলেছিলেন
Yes,
যে
Mr. Shengoto, please complete. This torja, please do outside court. Yes.
Sorry, I am.
Please complete your arguments. We are waiting for you.
This judgment was taken into consideration
Yes.
by the three-man bench of the Honorable Appeals Court.
Whatever
And-
judgments you want to cite it formally right now, so that tomorrow you don't cite any new judgment
Yes,
in reply.
Tomorrow they are saying or day after tomorrow.
Yes, whenever they cite judgments, you will just give reply to those.
2023 SC 512.
So we will take this and these three judgments.
Yes. And my lord, I say I will make
Page number
submission
কত,
that
page number
11A
কত?
is not applicable so far vesting is concerned.
No question of your will be making submission. Whatever submissions you have made, you
Yes,
have heard.
My lord,
In your reply, in your
Yes.
rejoinder reply, you will answer his
not-
questions.
Yes. So far vesting is
Page
Heard
number
learned
কত?
counsel for the parties at length on the review application.
2023
Full stop.
SCC.
The matter is heard in part.
One.
Full stop. For further hearing, let the matter be listed on August 27, 2025. Pathare দিয়ে দেবেন।
My lord, part and make it part.
Pathare, yes. Yes.
All these are on writ proceedings. 24
Maybe,
has
but
no
my lord, I have a case.
power. He is not.
Maybe, but I want to hear.
Question all these. Then we have to go to Indore Development Authority. Question of whether
Why they are so apprehensive? If it is hard, why?
Let them complete the sentence, please. Mr.
position of law as on today is this. Two types of proceeding. Just I mean, one.
Mr. Bera, please make your arguments day after
Yes.
tomorrow when you come.
The only thing I am
We'll hear you on that.
saying,
also.
it is not a case on 24.
Why you are so
All those
apprehensive?
cases
My lord, is
are on 24 of the Land Acquisition 2013 Act. Here in this case, 2024 doesn't apply.
No, that was what was held by the courts also. But
24
question is
doesn't
different
apply.
here.
Question is different, my lord. Yes, my lord. But
All
why
right.
they are so apprehensive? My lord is hearing the
I
matter.
appreciate.
Next,
He cannot dictate.
that part.
We are not hearing the writ petitions.
17,
Oh, 17 same order.
17 same.
Same order.
Let this matter be listed.
Appeal,
Let
two
this-
appeals. There are two
আচ্ছা
appeals.
তাহলে কমন করে দিয়েছে
Yes.
Subjects.
16 17
Yes.
এই দুটো তো একসঙ্গেই তো আছে আপনি আলাদা রাখছেন কেন 16 তো একসঙ্গে তাই
Similar order.
ও আলাদা করে দেখানো আছে?
হ্যাঁ, আলাদা করে।
আচ্ছা তাহলে আপনি করে দিন লেট দিস ম্যাটার 17 এ অর্ডার হবে লেট দিস ম্যাটার বি লিস্টেড অ্যালং উইথ RVW 208 of 2025 on August 27, 2025. এটা এবার ইন করে মানে উইথ করে দিয়ে দেবেন।
Obliged.
পরশুদিন হচ্ছে আজকে।
Private to appear for the private respondents.
But, 18 and 19, I'm specifically appearing in 19, but I'm little hesitant to start it because it must spill over to the next half. But I have,
if you have some difficulty
today. That's the only thing. I can start. I mean, otherwise,
no, then instead of
make it not today.
not
Let us
today,
try
take
it tomorrow.
Yes. Since learned counsel appearing for the petitioners have some difficulty after the recess, comma, let the matter stand over for the day and be listed tomorrow under the same heading. Thank you. Learned senior counsel করে দেবেন ওটা। Yes.
আমাদের নামগুলো দিয়ে দিয়ে দে নামগুলো কি প্রথমটাতে কোর্ট
The respondent was supposed
You're trying to threaten us at the outset with the number of books you are carrying. The bag is very ominous. What is the matter about?
My Lordship had heard this matter, section 37.
Oh, that too.
Yes, Your Honor, Mr. Suman.
No, this may require books. Yes. Yes.
My lord,
On your pair, it was adjourned on the last occasion.
yes, my lord, we had mentioned the matter today on the grounds that Mr. Shah is not
Oh, you
available.
had mentioned in the morning, perhaps. When do you like to?
Thursday, my lord.
Thursday, you have any difficulty?
No, Thursday already.
Thursday, all right. So today is 25th. We are putting it on Thursday, 28th. On the prayer of the respondent, the matter is adjourned till August 28, 2025. Please come back. 28th August, Thursday. Same heading. File direct. Yes. Can't challenge. Mr. Bandyopadhyay was continuing.
My lord.
What happened to him?
Stuck, my lord. He's
We
on
are
his leg.
keeping it after the recess.
My lord. Kindly, my lord.
So you're making it Passover only then.
Okay.
Passover.
Grateful.
Because it's a part-hard matter.
Yes, my lord. Yes, my lord.
Yes, it's a part. So Passover. Or should we make it not today?
My lord, Passover is okay.
Passover. Wait.
Yes.
Grateful, my lord.
Yes.
Is matter appearing for the petitioner, my lord?
Yes.
My lord, in short, I am stating the
Yes,
fact.
Mr. Mondal.
My lord,
These matters are mostly very short, actually.
yes, my
We are
lord.
finding that.
Yes.
Right.
My lord,
It will take 5 or 10 minutes. 5 minutes.
You said that on the last occasion. Yes.
Whether
Yes.
the respondent number 5 and the petitioner will get the benefit of the death benefit of the railway employee. Or not.
You are for those respondents.
I am the third wife and he is the second wife.
First wife is not before us?
No.
Yes, my lord. My
First wife is also
expired on long.
Expired.
good for her. Yes.
Yes, my lord. The husband of the petitioner man expired in 2007, my lord.
My lord,
My lord.
prior to going through the last order, kindly peruse. Last order.
Yes,
And
my
this is the affidavit. On 6/12/2024. And I bar করে নিয়ে এটা।
Oh, you are the nominee.
Yes.
So you have.
I am the nominee.
This is the undertaking that you will hand over her share.
Yes, my lord.
So you can settle that right now.
Yes,
We'll
ma'am.
take this undertaking on record. Can you please give a copy of this undertaking to him so that they are also assured? You have already given.
Yes, already given.
So very well, let us dispose of the writ petition
my
on
lord.
this.
Yes, my
Because
Let her
my client age is 72.
Oh.
His client age is 80 and died on 2007. And the railway authority.
He was 100 then when he died?
Correct.
So this can be settled then. There is no other disputing party.
No.
Only you and you. So you are the second and she's the third wife.
Third wife.
I'm this petitioner's second wife.
What is the name of the husband?
Noor
Ali Khan.
Noor Ali Khan.
Yes, sir.
So this is for retirement. What is sorry? No,
Retire-
compensation.
Retirement benefit.
Retirement benefit.
Pension due to death. Due to death.
Death benefits.
Death benefits.
The present dispute has arisen out of the entitlement of the petitioner and the respondent number 5, respectively the second and third wife of deceased Noor Ali Khan, the employee, with regard to the death benefits of the said employee. First up, next para. Pursuant to a previous submission made by Learned Counsel for the respondent number 5 on December 6, 2024, an affidavit of undertaking is filed today with a prior copy to the learned advocate for the petitioner. First up, next para. In the said affidavit of undertaking, the respondent number 5, the third wife of the deceased employee, undertakes that after getting the entire benefits of her deceased husband, she shall share the benefit amounts along with interest accrued thereon through account pay check in the name of the petitioner within 7 days from the date of receipt of the entire benefit amounts, including subsequent pensions with her. Full stop. Next para. We find from the records that since the respondent number 5 is the nominee of the deceased employee and as such, the receiving hands of the death benefits in law, the undertaking given by the respondent number 5 is in perfect consonance with law. Full stop. Since both the petitioner and the respondent number 5 agree to such resolution of the issue between themselves, no useful purpose would be served in keeping the writ petition pending. Full stop. Accordingly, WPCT 6 of 2023 is disposed of in terms of the undertaking filed today by the respondent number 5, directing the respondent authorities, being the employer of Noor Ali Khan, to pay the entire death benefits of the government employee, namely late Noor Ali Khan, in favor of the respondent number 5 as expeditiously as possible, preferably within 2 months from date. Full stop. Next para. You are for the union. 3 months.
No, but I talking about fund is ready. You are making embarrassing for the to whom will pay.
No, we are directing that.
Your lordship kindly pay me, my lord. I was.
No, we have taken her undertaking. You will pay to her. She will pay to her.
There are other problems. That is why this will open a floodgate. My lord, in the event the money is given.
What is the problem?
Your lordship kindly pay my opposition to the undertaking.
No, just tell us, Mr. Bhattacharya.
Rule says otherwise. She is not the validly married wife under the rules. Without permission, got married. She is not the lady who is before your lordship. No iota of his claim before the authority. Somebody has claimed. Here, my lord, the two persons are claiming. There are other sons and.
Respondent number 5 is entitled. She is the nominee.
Nominee.
So you pay to her.
Can before the read court, a third case may be made out. Let you go before the tribunal and make appropriate.
No, but you cannot have any issue on that, Mr. Bhattacharya, because your client is the employer. Yes, we are, as far you are, insofar as you are concerned, we are directing you in the writ petition to pay the amount to her. It's her undertaking to the court that she'll pay to him. No, you have to pay under the law to respondent number 5.
We are ready to pay. We are facing only embarrassing.
Do that. We'll direct you to pay to respondent number 5. Your duty ends there.
Your lordship kindly make it clear that this will not create any evidence. The precedence in future for
what precedence? You have to pay to the nominee. Your precedence is only restricted to your payment is to the nominee.
Not as a wife, only as a nominee.
No.
As
wife. Yes. So we will make that clear.
Her name is there. Firstly, my submission before your lordship, my lord. She is not before the court. She is the respondent number.
She is died.
she is not the claimant, my lord, claimant is other person. So, my lord, now before the reed court, she has come and filed an undertaking compromise. My lord, this is not a civil matter that compromise is entered into. This is my first submission. My second,
আচ্ছা, তো ওইখান থেকে তাহলে কেটে দিন, ওই যেখান থেকে বললাম যে অ্যাকর্ডিংলি নো ইউজফুল পারপাস উইল বি সার্ভড, ওইখান থেকে কেটে দিন। না না, ওখান থেকে না, তো ওখান থেকে কেটে দিন, ওখান থেকে কেটে দিন। ও না, এই সেন্টেন্সে তাহলে কাট, সিন্স থেকে কাটতে হবে। Your objection is that this cannot be taken as a precedent, one. Secondly, it will create a dangerous precedent because
without lady without married, my lord, with the permission of
you say that petitioner is not a validly married wife. Second marriage was not valid.
Well, when she got married, that time her husband was alive.
No, my lord, that is not true, my lord.
No, no, no.
Her previous husband was alive.
What evidence? I have annexed that evidence.
We cannot decide that. That can be decided only by a civil court. We'll make it clear, Mr. Bhattacharya, that we are not adjudicating on the right of the petitioner. We are going only by this undertaking. And as far as you are concerned, you have to pay to the nominee as a nominee. We'll make that very clear. Very well. We are recording that argument and recording this.
My lord, I am the wife. Kindly see the.
Your wifehood is not being disputed. It's his, Mr. Mondol's client's wife.
In spite of that, I will pay.
Yes, you are gracious enough. Next. Next.
Because nobody is.
Other thing you lost your record, my lord, that she is not before the as a writ petitioner or before the original way, my lord.
Where ছিল?
Next para. Learned counsel for the Union of India stroke employer, however, submits that the understanding between the respondent number 5 and the petitioner, writ petitioner, is divorce the law. First of, it is contended that the writ petitioner was not the legally married wife of the deceased employee, Noor Ali Khan, since at the time of such marriage, with the deceased, the writ petitioner has had her previous husband existing.
No, my lord, not with petitioner husband, not. That
Not
is
writ petitioner husband?
No, my lord. Respondent number 5's husband, that is.
Kindly peruse my opposition to.
We'll take it up after the recess. এটা ফেরত দিয়ে দিন ওনাকে, পুরো অর্ডারটা কেটে দিন, আমি নতুন করে।
Sorry, my lord, I was held up in other building, my lord.
কি করছেন? ফেরত দিতে বলছো, ওটা রিসেসের পর নেবো।
Recess পর।
Please keep everything with you. After recess, file it. We'll record. Do this thing. That will be injustice to all of you. We'll take it. This is your first matter after recess.
দাঁড়ান।
আর টাকা দরকার নেই, দেখেন ওটাই।
এগুলো আমাদের।
অরিজিনাল এগুলো কোর্টে ফাইল।
আরেকটা ডেকে নিলে তারপরে এটা ধরতে পারবো না।
ওটা তো
ঠিক আছে।
আমাদেরটা কোথায়? ভিতরে।
আরে বাবা, এটা
এর পরেরটা দেখুন, এর পরেরটা দেখুন।
এই দেখুন, সুকুমার ভট্টাচার্য, সুকুমার ভট্টাচার্য।
আরেকটি।
We start with this matter after the recess. Mr. Bhattacharya, just get ready and we'll.
Sorry, my lord.
No. Why should you be? Yes.
Lordship kindly peruse.
Yes, Mr. Bhattacharya, we will hear you first because we have heard them.
Who
You
is
please
the-
take your seats, Mr. Mondal and Mr.
Who is before your lordship? Who before you tribunal? Who is before your lordship?
Right.
Your lordship kindly peruse my affidavit in opposition.
Yes.
Once. To the writ petition.
Yes.
Yes. And your lordship kindly peruse, my lord. Page 18, the genealogical table. That will shorten the issue.
Yes, yes. Yes, Mr. Bhattacharya.
Noor Ali Khan,
Yes.
second husband of the petitioner. That is, my lord.
How do you know this second husband?
The welfare inspector was appointed.
Oh, inquiry. Very well.
And my lord, Meherannesa Bibi is the first wife, left hand.
Yes.
Then middle, my lord, Chakina Bibi.
She died, first wife died before his superannuation, so no difficulty on that. But she had left heirs also.
Yes.
Ah. Very well.
And my lord, Chakina Bibi, the second wife petitioner living, she is having, my lord, husband, Muhammad Said, first husband petitioner died, death certificate not produced. According to us, this is, my lord, problem.
Her case is that that husband died prior to this marriage.
Yes.
Must be that.
Then no issue.
Hmm.
This Chakina Bibi, who is before your lordship, no issue.
Hmm.
But from her husband, first husband, there's the issue, my lord, that your lordship will find. And the third husband, Farida Bibi.
Below Chakina Bibi, we could need not look into because if yes, if she either she gets or does not get, they don't get. So according to you, Farida Bibi, third wife is the actual second wife.
Yeah. Farida Bibi is the well not. She is also not validly married wife because while she married, my lord, she has a husband.
She also had a husband. You have not stated that here.
Yes.
Oh, first husband. No state.
And she was a Bengali and converted.
Bengali Hindus.
Hindu.
Bengalis are Muslims also.
Hindu. Sorry. So that was not.
So according to you, apart from the first wife, all are all the other wives had their husbands living at that point of time.
And their sons are there. And my nomination, your lordship now currently peruse the nomination.
Their sons are immaterial. Only petitioner, the first wife's sons are material. They can claim heirship.
And I do not know whether the third wife, Farida Bibi, who is the nomination. Nomination, yes.
Nominee, yes.
And your lordship kindly peruse, my lord, the nomination form and the declaration.
Yes, please.
That is page 13. This is not the nomination. This is the percentage. Has your lordship got it? Page 13.
Yes.
Farida Bibi, wife. That third wife. And Shaukat Ali Khan, son. Has your lordship got it?
Yes. Whose son? Oh, first wife's son.
And in case of death of wife, son, 100%.
So wife, he says Farida is wife. In her demise, on her demise, son.
Son will get. And now, before your lordship, the Chakina Bibi is the alleged second wife and third wife is giving undertaking will take.
But Mr. Bhattacharya, page 13, if you see carefully, date of birth, now Farida Bibi has been given 100% if she is alive. So not that Farida and Shaukat get half.
No.
Nominee at least.
After Farida Bibi?
Then 100% son. But during her lifetime, she gets 100%.
Yes.
As per this.
As per this.
All right.
And the next page, my lord, page 14, Farida Bibi, Shaukat Ali, this is there. And the nomination paper is, my lord, just a minute.
Nomination is next page.
Agir page, actually.
This is
page 11.
Yes, should be that.
Mother Katu Khatun, another wife's name is appearing, my lord. Katu Khatun and wife. And death certificate, your lordship kindly peruse page 12, produced by his son.
No, but neither Farida nor Shakina are mentioned anywhere. Shakina is not mentioned anywhere, and Farida is not mentioned in this. But where is the nomination? Is there any column?
There is a form subject to correction.
If you can please show us that.
Nomination form. That your lordship, page 14. Page 14. Declaration regarding family members of this is the.
That is a declaration regarding family members, but family members need not be nominee. I can make someone else a nominee also under.
Anybody can be.
Anybody can be.
Anybody can be nominated. Now your lordship kindly.
Nominee at the base page 13 can be the.
And now your lordship kindly peruse my opposition to their undertaking once.
Oh, Mr. Bhattacharya.
Yes.
Page 13 is the nomination, because here if you see above that table, here it's written name and address of nominees stroke nominees.
Yes, yes. Grateful to you.
So therefore, page 13 is the nomination. Nomination is Farida.
Farida and son, in case of death.
In case of, yes.
Now your lordship kindly peruse my opposition to the undertaking.
Where is that?
I have just filed.
Oh, opposition to the undertaking. Yes. Oh, you filed an opposition to the undertaking also?
Yes. Because when the matter was taken up, that was not before your lordship.
Reply is there.
Just now filed, my lord. Very thin.
Just now filed today?
Yes, yes.
Konta?
4 pages.
Yes, yes, yes.
Kindly peruse page 3.
Yes.
Relevant portion. I state that there is no dispute of fact that the deceased employee has nominated Farida Bibi as nominee at column 6 and in case of death, wife, son, Sarkat Ali Khan. That is there. I state that mere declaration in the name, respondent number 5 as nominee does not give her right to accept the family pension as third wife because according to the respondent's authorities, the respondent number 5 is not the validly married third wife under Rule 75 of the Railway Service Pension Rule 93. I further state that the deceased employee is not entitled to benefit under the General Law of Nomination Act because in the instant case, the deceased employee governed by special rule as there is a contract between the employer and the employee. I also state that neither the petitioner nor the alleged nominee, respondent number 5, is the validly married wife under the Mohammedan law. Therefore, both the petitioner and the respondent number 5 should satisfy the rules, provisions of Rule 7 read with Rule 75, Rule 21 of the Railway Service.
You got those rules?
Yes.
Okay, can you cite those? Thank you.
Rule 75, relevant, my lord.
You rely on 7 and
7, yes.
And 21.
21 is not there, my lord. 21 is difficulty because they have given an illegible copy.
This is the 21.
21.
You have got the rules?
That is the rules.
The copy is I am having, my lord, not.
Union doesn't have a copy, but you have.
No, I am having, but
illegible.
I cannot give you lordship for
Achha. I downloaded from the.
But we have that.
Yeah. Will lordship kindly peruse Rule 75(7).
Oh, you have in your affidavit you have 7.
No,
Only 7.
Yes,
So you are relying 75(7).
And also 21.
Also 21, yes. 75(7). Let us see that. Where is 7?
My lord, it starts with 75, the first page. And
you can 5, 4, 5, 6 up to 6 you have got.
7 is not there.
7 session again. No, that is explanation. Oh, okay.
Is there any mistake?
7 to Paching. Yes, 7. But the family.
Where the family pension is payable to more widows than one, the family pension shall be paid to the widows in equal share. These all are validly, legally married. No. B, on the death of the widow, her share of family pension shall become payable her eligible child. And in the undertaking, these provisions as the Farida Bibi and Chakina will take and leave.
Oh.
After their death, nobody will get.
So your rules specifically restrict it. What is the meaning of nomination then, Mr. Bhattacharya?
Well, nomination is, my lord, under the railway, the service pension rules, what is provided, that will prevail, my lord.
But then there must be some rule regarding nomination also. We don't have that before us. The entire rules are not before us.
70, madam.
70.
70. 70 is not with us. Do you have a copy of 70 also?
We want an order from your lordship so that we are not faced.
Understood. You have to protect yourself, definitely. Otherwise, you will be hauled up. 70. But writ court has its limitations. We cannot decide title.
Yes, and another thing, my lord, so far the first point I raised before your lordship, my lord, who is before the writ court? Whether the writ court can go into what is not pleaded, my lord, to that I am relying a judgment.
What has been not pleaded?
That third wife will get the undertaking is made. The
undertaking is
before the tribunal, the Chakina Bibi was the claimant. Whether before the writ court there can whether
what is the
can
cause of action in the writ petition against respondent number 5?
No.
What is the cause of action disclosed in the writ petition
Writ
against?
petition is, my lord, your lordship kindly.
What is your cause of action?
My lord, they had
one line. What is the cause of action against respondent number 5?
Just my lord, they had already decided to give all the my lord pension benefit
to
the
5.
respondent of 5.
Take.
That is why.
Can you please give a copy of this rule 70 to Mr. Bhattacharya? His rules, but he does not have a copy. Or you can share your copy so that he can have an idea of
my copy.
Yes,
Just
but that is returnable, Mr. Bhattacharya.
Yes. And my lord is very
70.
72.
70.
70.
70 continuation.
70
family member.
Including judicial separated wife and wives in the case of a male railway servant. Wife and wives including judicially separated wife. This is not judicially separated wives in case of a male railway servant. But that wife should be
family member, not nominee.
Validly married wife and family members.
But difficulty is, Mr. Bhattacharya, the employer is also not a civil court. I mean, how do you, if the writ court can't decide, the employer cannot decide also. How can you decide who is a family member, who is a
civil court to decide the issue?
And you will retain the amount. You put it in an escrow account then,
yes,
or some account with your own account, nationalized bank.
As your lordship, we will keep it. Well, our case is we are facing embarrassing because of this claim.
What do you do in these cases, according to you? If there is a civil dispute, then what do you do? You decide in your own way and then leave it on the court.
No, what the civil court decide, we will pay them. But
obviously,
till that period, we
writ petition, our hands are bound. You are right.
And I am before your lordship so that the right order is passed, my lord. Without misleading, I cannot get a benefit of the order passed by your lordship.
Understood. Yes, let us hear them then.
My lord, I am asking myself, what is the purpose of this nomination paper?
We are also asking ourselves.
Because of that, a person.
But the rules do not give any answer to that.
My lord,
there is nothing to even, recognize a nominee. There is no provision for nominee under this.
Nominee, and it has been stated that I am the wife. Column 1.
You have stated, they have stated, it's disputed. Their inquiry reveals you are not the wife.
Not supposed to say that.
You saying that does not mean that automatically it becomes sacrosanct. If there's a dispute raised by whoever, because here the dispute is regarding disbursal of this death benefits, right? So employer has a right on that also to say something on that. It's disputed. Now, in the writ petition and in the writ petition, as per her pleadings in the writ petition, has disputed your status as a second wife.
No, he has not disputed. He said that I am also one of the wife.
Acha. He has not disputed his status.
No.
But then you can collude and this just deprive Shaukat, the son of the first wife, and the daughter of the first wife.
Shaukat is entitled only after the death of the nominee and the wife.
Apparently not. As per Rule 70, which you have handed over rightly.
Kindly.
If you please come to your copy is with Mr. Bhattacharya, you can take that
No,
back.
no, I have.
Yeah, another copy. Now,
another.
It has to be paid to the family in the manner the word uses family.
My lord, kindly see
And
page
family has been defined wives or wives, etc.
So,
Including judicially separated wives.
I am coming within the purview of clause 4.
Clause, which one? Say, tell us.
Last portion. 74, last portion.
Yes, 4.
70, subclause 4.
4. But you are not family if you are not legally married with him.
Definitely, because my husband has stated that
You
I am
say
the-
that. You say
I am not stated. My husband stated that my wife
his
is
form.
so and so.
In his form.
Yes, because he was the employee. I was no access there. My husband stated who is the wife, who is the son. Son name is there.
Your husband stated that,
yes.
but your husband's credibility is in doubt because with utmost respect to the deceased, because the first wife has come up, second wife has come up also. You are probably the third wife.
I am third wife.
So second wife is also there. Second wife was there. He suppressed that and he disclosed you to be the only wife.
It is not said only wife.
See, but he mentions, the husband mentions Shaukat as his son. Shaukat was born through the first wife.
Yes.
First wife is still alive.
No. First wife died prior to marriage of the second wife. That is Chakina.
Yes.
kindly
That
see
is
the-
Shakina is not even mentioned. So the writ petition should be dismissed then. Shakina has no locus standi.
My lord, kindly hear me. Page 19, my lord, kindly for a moment.
Page 19 of?
19 of his
Writ
application.
petition.
Writ petition.
Writ petition.
Writ petition.
The order of the magistrate.
Page 19 of the writ petition.
Yes. Yes.
This, my lord,
What is this?
Fifth line, started, my lord.
What? Miscase under section 125?
125.
CRPC.
Yes. সাক্ষ্য মাই লর্ড আমি কামিং মাই লর্ড সাকিনাতা দরখাস্তে এবং সাক্ষ্যে বলেছে যে তার প্রতিপক্ষ মুসলিম সারা অনুসারে বিবাহ হয় এবং 1395 সালে 7ই জ্যৈষ্ঠ তারিখে এই বিবাহে একটি কাবিলনামা তৈরি হয়। প্রতিপক্ষ দরখাস্তকারীর সঙ্গে বিবাহ হয়নি বলে আপত্তি করলেও অন্তর্বর্তী খরপোশ দরখাস্তে আদেশে উক্ত বিষয়ে সিদ্ধান্ত গৃহীত হয়েছে যে পক্ষদের মধ্যে মুসলিম সারা অনুসারে বিবাহ হয়েছে, বিয়েতে দেনমোহর হয়েছিল এবং কাবিলনামাতে উভয় পক্ষের সই আছে। সরকারি রেশন কার্ডে প্রতিপক্ষের নাম সাবিনার স্বামী হিসেবে উল্লেখিত আছে। প্রতিপক্ষ কন্টেস্ট করেনি। দেন মাই লর্ড, কাইন্ডলি নেক্সট পেজ মাই লর্ড, রিগার্ডিং দি এক্সিস্টেন্স অফ দি ফার্স্ট ওয়াইফ during the marriage of
125 is not an adjudication.
No, my lord, that is not. But Sakho, my lord, kindly see. Next page, my lord.
Yes.
Next page, my lord, fourth line, fifth line. প্রতিপক্ষ বলেছে, প্রতিপক্ষ my lord, employee, husband বলেছে যে সে রেলে গ্যাংম্যানের কাজ করে এবং বর্ধমান রেল কোয়ার্টারে থাকে। মেহেরনেগার বিবি তার প্রথম স্ত্রী, তার মৃত্যুর পর ছাকিনা হাড়ি হোলা ইত্যাদি বিক্রির জন্য মাল রাখতে বলায় প্রতিপক্ষের সঙ্গে তার আলাপ হয় এবং সে প্রতিপক্ষর মাকে দেখাশোনা করবে বলে, ভাত জল করবে বলে তার সঙ্গে থাকতে শুরু করে, কিন্তু তার মায়ের মৃত্যুর পর থেকে সে আর সেখানে আসেনি। প্রতিপক্ষ আরো বলে যে বর্তমানে সে ফারিদা বিবিকে পুনরায় বিবাহ করেছে। ফরিদাকে প্রতিপক্ষ বিবাহ করেছে কিনা সে দেখাটা অপ্রাসঙ্গিক, কারণ প্রতিপক্ষ মুসলিম ধর্মাবলম্বী বলে একাধিক বিবাহ করতে পারে এবং ছাকিনা যে তার বিবাহিত স্ত্রী তা উপযুক্তভাবে প্রমাণিত হয়েছে।
উপযুক্তভাবে প্রমাণিত হয়েছে। How does he say that? The husband does not admit that. He says that you were there to look after him.
No, my lord.
Not nowhere recorded that husband has admitted.
Kabilnama, then Kabilnama, my lord, Kabilnama, everything is there.
What is that?
Kindly see Kapil Lama.
It is not a part of the records. No, you have to establish your rights before a civil court.
No, my lord, then, my lord, that will take time, my lord. They are, that is why, my lord.
No more.
At first, my lord, that was decided by the
Otherwise,
tribunal.
people can call it because
Kindly
the
see-
son's name is mentioned. What happens to the son?
Yes, my lord, then, my lord, kindly page 30.
Then the son should be included here.
No, my lord, that 30. Yes, my lord, 30.
Your husband's form, employment form, the nominee form mentions the son.
Yes, my lord, then page 30, my lord. Page 30.
30, yes.
My lord, affidavit. Shakina Bibi. Then, my lord, 2 Farida Bibi. 3, my lord, Shaukat Ali Khan. 3.
Then how can you deprive Shaukat?
No, my lord, that is
Shall be divided in equal share between
she will also get, my lord.
that we have
Only
just-
pensionary benefit will get both the wife,
We have
according to.
objection to
And
accept.
other benefit, my lord, according to Muslim law, my lord, they will get. That has been
So that the
decided.
pension shall be divided in equal shares between 2 widows.
Yes,
Shaukat
ma'am.
admits that.
Yes.
These are to be proved before civil court.
Pension, my lord, both the wives, my lord. And other benefit will be divided. They are agreed, my lord. I can produce them also.
Shaukat.
Shaukat and another daughter, my lord.
The daughter is also a signatory here, no? Daughter has not signed.
I have signed, but my lord.
Daughter is neither a party nor signed.
Yes, my
What
lord.
happens to the daughter?
Married daughter, my lord.
That is before the magistrate.
But Mr. Bhattacharya, one thing, if Farida has been mentioned as the wife, so the employer probably has to go by that. Can the employer decide? Employer is also not a civil court.
Rule 21 also provides, that is unfortunately,
Rule 21.
permission is to be taken before the marriage.
No need.
So far, if your lordship goes by nomination, no issue. If your
Permission,
Not for
if under the law he has a right.
Right. But even if the
A Mohammedan has a right to marry.
Yes, that is there.
So how can you restrict the legal right by way of your rules?
And
why should they take a permission of you?
My lord, I have given one single page. That is Rule 21.
No, this is a bad rule and bad in law.
May I place it?
Permission, let us see.
No, 4 is there.
No railway servants, 4.
No, personal law. Personal law. কোথায় গেল এটা?
He has not challenged the rule.
Yes.
Not required.
No, but railway servant who has married or married a person other than national Indian, provided that the government may permit a railway servant to enter into or contract any such marriage, if it is satisfied that such marriage is permissible under the personal law. How can the government decide on that?
I was myself.
This is utter discrimination, Mr. Bhattacharya.
That has not been
Whom I
challenged.
married, I will take the permission from the employer.
This permission will hold. This is not obligatory. Not obligatory. A Mohammedan under the law can marry 4 times. Mr. Bhattacharya, it's gross, contravention of Mohammedan law. So even then, what does it boil down to? It boils down to that he can marry a second time or a third time or a fourth time up to. So first wife is dead. That is an admitted position. Your inquiry also reveals that. His son is there. They have produced an affidavit to show that the son has agreed.
Before the criminal court.
We are not going into those things. Even without going into those, this deceased employee has stated only the name of his son and Farida. If you go by that, Farida is the third wife. You say that's an invalid marriage. We may hold that employer cannot decide that, and we will make it an order of the court so that you are protected. তাহলে আমরা এটা করছি যে first wife admittedly deceased.
And that point, Chakina Bibi is before the court. Whether your lordship will decide this as a
Chakina Bibi is there. Chakina Bibi will not say Chakina Bibi has any entitlement per se.
But yes,
they have decided to give. They have filed an undertaking. It is their choice to honor that undertaking. We are not deciding. We will make it clear.
The undertaking is filed by the respondent in a writ petition, not by the petitioner.
Being directed by the school.
No, because Mr. Bhattacharya, the writ court may hold very well that no, because it's a dispute between petitioner and respondent of 5. Petitioner says you are going to pay to respondent of 5. That's their cause of action.
Respondent of 5. The the approach before the court, give me. And thereafter,
No,
my lord,
petitioner, suppose we may hold, the court may hold that not the petitioner, but respondent number 5 is entitled. If we hold that, respondent number 5 says, if the court holds that, I am willing to give half of my share to her.
and what about, my lord, that part of the sons and that will
No,
also.
everybody's entitlement remains.
Yes.
We are not deciding anybody's entitlement. We will only say categorically that the writ court, neither the writ court nor the employer can decide who is the heir. And we'll also say that we go by only the nomination in the form, proper form given by the employer. Going by that, Farida is 100% if she is alive. Farida gets 100% as the receiving hands. And as per this, your family, this will say that for the purpose of disbursal, will deem her to be family because she has been disclosed to be a family in that. And the employer is not a civil court, cannot decide who is a family. We'll only say that. This will say, we'll read this rule into the declaration made by the husband, because during his lifetime he was never penalized for violation of rule of second marriage or something like that. So the employer cannot after his death raise that issue.
Only your lordship.
And it was made in the year 2002.
Yes,
2002 that declaration was made by
nomination.
2002
No.
declaration made, 2007 he died.
In service.
Very. The present proceeding, all of you please take your seats. We'll just, if we are wrong anywhere on facts, please just point out. We'll request you to do that. The present writ petition has been filed under peculiar circumstances. First up, the writ petitioner, claiming to be the second wife of one Noor Ali Khan, since deceased, stakes a claim to the death benefits of the said Noor Ali Khan on his demise from the respondent stroke employers of the deceased. Who's up next para? Learned counsel for the writ petitioner submits that the cause of action of the present writ petition was that the petitioner apprehended that the employer of her deceased husband was about to disburse the death benefits of the husband in favor of the private respondent number 5, one Farida Bibi, who also claims to be the third wife of the husband. Push up next para. It is contended that at best, the respondent employers can distribute the death benefits of the deceased employee equally among the petitioner and the respondent number 5. Push up next para. Learned counsel for the respondent number 5 files an undertaking on behalf authored by the respondent number 5, whereby the respondent number 5 agrees to disburse half share of the death benefits of late Noor Ali Khan, upon receiving the same from the employer of the said deceased. Push up such undertaking be kept on record. Push up next para. Learned counsel appearing for the respondent authorities, who are the employers of the deceased Noor Ali Khan, raises an objection on the strength of the affidavits in opposition filed by the respondent numbers 1 to 4 against the writ petition as well as the written undertaking filed by the respondent number 5. Which the next para. Learned counsel for the union argues that the respondent number 5 was neither a petitioner before the tribunal nor the writ petitioner before this court, and as such, does not have the locus standi to author an undertaking. Full stop next para. It is also contended that upon internal inquiry, the respondent authorities have come to know that late Noor Ali has left several heirs, including one Shaukat one Shaukat Ali Khan, comma, the son of the deceased Noor Ali Khan to his first wife, Katu Khatun, Katoo Khatun, and daughter Manoja Bibi, Manoja Bibi, comma, also to the deceased first wife. Apart from them, comma, it is contended that there are no legal heirs in the sense that both Sakina Bibi, comma, claiming to be the second wife of the deceased employee, comma, had her previous husband living at the time she allegedly entered into marriage with late Noor Ali Khan. Full stop. Farida Bibi, comma, the respondent number 5, comma, claiming to be the third wife, also had her previous husband living at the time she allegedly entered into matrimony with the deceased employee. Full stop. Next para. Thus, comma, it is argued that neither the writ petitioner Sakina Bibi nor the respondent number 5 Farida Bibi have any locus standi to agree upon the death benefits of late Noor Ali Khan being distributed among themselves, comma, thereby depriving Shaukat Ali Khan and Manoja Bibi, comma, the original heirs of Noor Ali Khan. However, comma, and a nomination in writing, comma, in appropriate form, comma, annexed to the affidavit in opposition of the respondent employee, comma, indicates that the deceased employee himself indicated, comma, in the column of nominee, comma, Farida Bibi, bracketed, present respondent number 5, bracket closed, and Shaukat Ali Khan as his family, comma, describing them respectively as his wife and son. As per the said nomination, comma, Farida Bibi would get 100% of the death benefits in the case of demise of the employee, and in case of prior demise of the wife Farida Bibi, comma, the son Shaukat Ali Khan would get the entire death benefits. Next para. It is thus argued that in view of the complications created due to conflicting claims, comma, the respondent employer is apprehensive of suffering legal consequences in the sense disbursal is made either in favor of the petitioner or the respondent number 5, comma, who do not have any locus standi to get such benefit, comma, not being family members of the deceased employee. Next para. Learned counsel for the private respondent of 5 highlights the provisions of Rule 70 as well as Rule 70 of the Railway Services within bracket pension rules, comma, 1993, comma, since the deceased employee was employed under the Eastern Railway. Next para, it is argued that clause 4 within bracket of Rule 70 categorically provides that for the purpose of the said rules, comma, in relation to a railway servant, comma, wife or wives come within the purview of family. Next para. Since the respondent number 5 was mentioned by the deceased employee in his nomination as the wife or as his wife, comma, it is argued that the respondent number 5 is entitled to get the entire amount of death benefits. However, comma, out of graciousness, comma, the respondent number 5 has undertaken to share half such death benefits with the second wife, Sakina. Next para. A peculiar conundrum has arisen in the present case. Rule 70 within bracket 4 of the 1993 rules specifically enumerate the family of a deceased employee of the railways to include, comma, inter alia, comma, his wife. Next para. By obvious connotation, comma, a wife has to be construed as a legally married wife of the deceased employee. Full stop, next para. In the present case, comma, the employer of the deceased, comma, upon an internal inquiry, comma, have arrived at the conclusion that neither the writ petitioner nor the respondent number 5 were legally married wives of the deceased employee. Full stop, next para. Again, comma, Rule 21 of the 1993 rules, comma, which has also been relied on by the respondent authorities, provides that no railway servant shall enter into or contract a marriage with a person having a spouse living, comma, by providing an exception in the proviso thereto, where it is provided that the government may permit a railway servant to enter into, comma, or contract, comma, any such marriage as is referred to in clause 1 or clause 2, comma, if it is satisfied that such marriage is permissible under the personal law applicable to such railway servant and other party to the marriage, and there are other grounds for so doing. Full stop, next para. The question which arises is, comma, on a composite reading of rules 21 and 70, comma, 70 within bracket 4, comma, what would be the implication in the event a particular person is mentioned as the wife by the employee himself in his nomination, comma, whereas the employer disputes that such person is the legally married wife of the deceased employee. Full stop, next para. It is well settled that even the writ court cannot enter into disputed questions of fact which require evidence to be furnished, comma, let alone, comma, the employer, comma, in the present case, the Eastern Railway. Full stop. It is entirely beyond the domain of the employer to decide the question as to whether a person is a legally married wife of the deceased employee or not, or even the heirship of any person vis-a-vis the employee. Full stop. It is entirely within the dominion of a competent civil court to decide such issue upon considering evidence. Full stop, next para. However, comma, if in every matter, comma, a dispute, wherever a dispute as to disbursal of death benefits arise, comma, the matters are to be thrashed out before the civil court before the death benefits are disbursed, comma. In most cases, comma, the employer would merely have to raise an issue or objection regarding the heirship of the nominee and refuse to disburse the death benefits to such person, comma, thereby flouting the very purpose of the nomination left by the deceased employee. Full stop. That, comma, in our opinion, comma, cannot be a reasonable solution to the problem at hand. Full stop, next para. As such, comma, on a composite reading of the rules cited before us, comma, we are of the clear opinion that Rule 21, comma, inasmuch as the same mandates an employee of the railway to obtain a prior permission from the government before contracting a second marriage, even if it is permissible under the personal law applicable to such railway employee, comma, is directory and cannot be mandatory at all. Full stop. In any event, comma, even if such absence of permission might have an effect on the employment of the particular employee, comma, such rule cannot override the personal law of the person concerned and affect the validity of a marriage contracted between a railway servant and a third party in any manner whatsoever. Push up, next para. Thus, comma, for the construction of whether a person comes within the ambit of double inverted wife under Rule 70 within bracket 4 of the 1993 rules, comma, it is Rule 21 within bracket Rule 21, comma, proviso, comma, clause small a thereof is entirely redundant. Push up, next para. Rule 21 does not circumscribe in any manner the definition of wife in Rule 70 within bracket 4. Full stop. It is only for the civil court to decide, if a dispute arises, as to whether a person is a wife or not of the deceased employee. Full stop. In any event, the employer of the deceased husband does not have the locus standi even to raise such dispute before a civil court. Full stop. Next para. In the present case, therefore, we have to go by the golden rule that whoever was named by the deceased employee as his wife or other relation in his nomination shall be deemed to be sacrosanct for the limited purpose of ascertaining as to who would be the receiving hands of the death benefits of the deceased employee. Full stop. Next para. In the present case, it is to be noted that despite the rules providing for penal provision, providing for penalty being imposed against an employee who contracts a second marriage without permission of the government, no such action was alleged to be taken against the deceased employee during his lifetime by his employer. Full stop. Hence, such point cannot be raised at present, after the demise of the employee, post facto by the employer. Full stop. Next para. Hence, since Farida Bibi was mentioned as the wife of the deceased employee in his nomination form and was granted 100% rights to get the pension, and a prima facie notarial affidavit affirmed before the concerned magistrate has been produced by the petitioner and the respondent number 5 to prima facie indicate that Saukat, the son of the deceased employee, had conceded to the pension death benefits of the deceased employee being shared among the writ petitioner and the private respondent number 5, we do not find any reason as to why the employer should withhold the disbursal of the amount, particularly since respondent number 5 and the writ petitioner, the two rival claimants as to being the wife of the deceased employee, have agreed among themselves to share the death benefits. Full stop. Next para. Thus, however, we make it amply clear that since the writ court does not have the jurisdiction to decide on merits as to the status of either the writ petitioner or the respondent number 5 as the legally married wives of the deceased late Nur Ali Khan, such question is not being decided conclusively by us. Full stop. The above observations have been rendered for the limited purpose of deciding as to how the death benefits of late Nur Ali Khan, an employee of the Eastern Railway, shall be disbursed, regarding which we give primacy to the disclosures made by Nur Ali Khan during his lifetime in the nomination form, which was never challenged during his lifetime by the employer. Full stop. Accordingly, WPCT number 6 of 2023 is allowed, thereby setting aside the impugned order. Where is the impugned order? We have not looked into that at all. Page?
Last page. Page 50, my lord. Page 51.
51. Impugned order of the impugned order dated February 3, 2020, passed by the Central Administrative Tribunal, Kolkata bench in OA number 350/511/2019, and directing the respondent authorities, in particular, which respondent, Mr. Bhattacharya? Respondent 3? 4.
Exactly.
By directing the respondent numbers 1 to 4 to ensure that the death benefits of late Nur Ali Khan, the employee of the Eastern Railways, be disbursed in favor of the private respondent number 5 as expeditiously as possible, comma, preferably within 1 month from the date, from this date, comma, full stop, next para.
1 month.
Well, subject to 1 to 4, my lord, Union of India, General Manager.
Which one should we direct?
Divisional Railway.
Respondent number?
4.
তাহলে যে 1 to 4 বললাম, respondent number 4. To ensure না, তাহলে 3 and 4. 3 and 4 to ensure na, to disburse the death benefits of late Noor Ali Khan, comma, the employee of the Eastern Railways in favor of respondent number 5 within a month from date, full stop. Respondent number 5, comma, within a week thereafter, within 7 days.
This is an old case, but your lordship kindly make it 2 months, my lord. Subject
2 months, that's it. 1 month or 2 months?
Old records, my lord.
2 months. The respondent number 5.
Before puja, praying for before puja.
You don't have puja.
No, I don't have. But everybody
It will be given before the next. It cannot. It is not possible before the coming Eid. Should has to.
As your lordship.
So, the respondent 5, comma, within 7 days from receiving such amount, comma, pay half of the amount to the writ petitioner in terms of the undertaking given by the respondent of 5 before this court. Full stop, next para. It is reiterated that this court has not decided the respective right, title and interest or legal status of either the writ petitioner or the respondent of 5 or any third party to the writ petition vis-a-vis the deceased Noor Ali Khan, and it will be open to any contender to the heirship of late Noor Ali Khan to file a regular suit before the competent civil court, comma, if otherwise maintainable in law, comma, to thrash out such claims of heirship.
Your lordship has relied on the, but your lordship has relied on the under the declaration before the criminal court. There the signature of the son has been accepted by your lordships. Shaukat Ali Khan.
We have said prima facie.
I'm extremely grateful, madam.
And we are relieved now. We are relieved.
I'm extremely grateful.
You are protected by the court, yes.
It is my social service.
For you. After you get also, it will remain social service.
Both. I will not.
Very good. Appreciate it fully.
Actually, petitioner is a beggar. Since he
begging,
he used to come to my village for begging, my lord. That is why I
always he is making phone and crying. Sees.
Then it's really social service for both of you. Congratulations on that.
I'm grateful, man.
Husband, all sufferings for that husband.
That is my lord.
Husband was a. We should not comment in over here. পাসওয়ার্ড কি ছিল? পাসওয়ার্ড আছে, দেখে নিন, দেখি আছে কিনা, যদি থাকে তাহলে হবে, তা না হয়। Yes, you're there. Oh, yes. Passwords are waiting only. The others are not. Password item 22 it. Yes.
Lord,
Acha, we'll rise at 3:15 because I have another bench. Should we release the other matters?
I'll yes.
Should release the other matters.
তুমি replace start করবে তো?
Mr. Sarkar, if he finishes, he'll start.
Yeah.
So we have 25 minutes.
Yes.
We can release the others.
Well, probably I'll take 25 minutes.
Very. Other matters are released. Yes. No difficulty. Take your time. I mean, we're just asking for the purpose of releasing the others.
So, my lord, a brief recapitulation, my lord.
Yes.
The order of the principal secretary was under challenge, which was passed looking into an inquiry report by the deputy director,
yes,
which by an earlier interim direction, the principal secretary said that you go and re-inspect the entire place and thereafter give a report. I'll pass an order on the basis of your report. In the earlier order, the principal secretary made it clear that I'll pass the final order on the basis of the report. And at the time of the interim report, hearing was given to the petitioner. The petitioner has made up a case entirely on that basis that when passing the final order, you have not heard me. And to support his point, he has shown a plethora of decisions, which is on the point of disciplinary proceedings of a public servant. Now, my lord, I had taken your lordship through the inquiry reports. I have taken your lordship through the representations.
Yes.
And I have also shown that contemporaneously there was no complaint of getting the petitioner making the petitioner sign some blank documents, which case they have made up today that I was made to sign some blank documents. Contemporaneous letters I have shown, Malad, and I have also shown the interim order passed by the principal secretary and the inquiry report by the deputy director and the final order, which is based on the inquiry officer's report. Now, Malad, ultimately what transpired, Malad, what was the end result of this inquiry was that 3 points have been held. That is at page, inquiry officer's report is at page 78 of my opposition, if required, Malad. The 3 points have been held against the appellant here, and 1 point has been said to be against the private respondent. And the principal secretary had weighed the points and said that I choose the lesser evil. I'll choose the private respondent. Because the private respondent had produced a land which showed Bash Bagan in the record of rights, and therefore he has said that I am condoning this. This, Malad, I have dealt with by showing page 1.48 of the book, which is entry number 32 of Form C, which gives the leeway that Bastu commercial, etc. That form was there, Malad, for your lordship recollection, which your lordship asked me to put it in the written notes. So, Malad, actually no condonation was required, but still the principal secretary has weighed in favor of the private respondent after hearing all the sides and all the points. Now, in support of my arguments, Malad, I had shown decisions that as far as the locus of the unsuccessful candidate is concerned in challenging the process, and I have shown it in the context of FPS dealership, not in the context of recruitment. And I have shown, Malad, that how far, Malad, judicial review is applicable for a selection process of FPS dealer is concerned. That is MAT 2084 judgment I have shown, Enterprise, MAT 2084 of 2024. Then I have shown, Malad, that the similar prayers were there in the earlier round of writ of prohibition, but there was no prohibition of the other, in the other round to give the license to the private respondent. So while the principal secretary was hearing the appellant hearing, the principal secretary had also issued the offer letter to the private respondent, but not the license itself. The license was itself issued after the dismissal of the writ petition, order of which is under challenge with your lordship. Then I have shown, Malad, to your lordship, Malad, 2015 volume 8 SCC, that the law applicable as on the date of application will be applicable. So, law applicable as on the date of advertisement will be applicable, because the recruitment process starts from the date of advertisement. For that also I have shown page Prakash, that is 2005 volume 2 SCC. And I have also shown that there is no pleading of prejudice either in the writ petition or in the supplementary affidavit or in the stay application or in the affidavit reply. This point helps me, Malad, because in all the points of natural justice, the petitioner has to plead and prove a case of prejudice which has worked against him. Now, Malad, I am left with 4 more decisions to be shown. Now, Malad, since the entire case is, Malad, based on natural justice, Malad, kindly take 1976 volume 4 SCC, page 765. নতুনগুলো এসে গেছে? আসছে? এসে গেছে? না না, নতুন আরো দুটো নতুন দিয়েছে। Malad, will kindly take paragraph 25. This is what I was referring to, Malad. Without knowing the writ petitioner, Lord Denning had observed something which is absolutely applicable to the appellant. Can you take the last page, second last paragraph?
Yes, 25.
In the entire background of this case, we find a passage occurring at page 803 in the judgment of Lord Denning, Master of the Rolls in the case of R versus Secretary of State of Home Department, quite apposite to be quoted. The passage runs thus: the rules of natural justice must not be stretched too far. Only too often the people who have done wrong seek to invoke the rules of natural justice so as to avoid the consequences. So, Malad, in other words, Malad, the rules of natural justice should not be stretched to a point that my in-house proceedings is reduced to a nullity, because at every round someone will come and say, I have not been heard, this document has not been considered, I have not been supplied with this document, my lord. And my lord, going back to my argument, my lord, your lordship will have to see that they are an applicant in a selection process. They cannot claim a right as tall as that of a public servant in a disciplinary proceeding. My lord, while I was reading these judgments cited by my learned senior Mr. Sarkar, my lord, for distinguishing it, a golden thread that appeared to my eyes, my lord, subject to correction, is that all those judgments pertaining to disciplinary proceedings ultimately end in a punishment. The petitioners came and challenged that punishment in a way. They came in a judicial review saying that your process adopted to reach the punishment was wrong. It may be minor, it may be major. Meaning that civil consequences of a punishment itself is distinguishable to our case, where it is an applicant seeking only a fair selection process. He has rights, I'm not denying it. But rights will also have to be compartmentalized. Fundamental rights is not same as statutory rights, not same as customary rights. Here they are not being entailed with a punishment. Therefore, the standards applicable to give a civil consequence equivalent to a punishment is not the same standards which are to be applicable for a participant in a selection process. Your lordship will only see my process was fair or not, and not to the extent of preponderance or probability, etc., etc. Now, my lord, on the stretching of natural justice, my lord, as I was placing, if your lordship kindly takes 2020, volume 18 SCC, 752. And it is paragraph 7 and 8. Yes. It is equally well settled that the principles of natural justice must not be stretched too far, and in this connection reference may be made to the decisions in Sohanlal, Mardia Chemicals, and Canara Bank. In Hiranath Mishra versus so-and-so, this court held that the principles of natural justice are not inflexible and may differ in different circumstances. Rules of natural justice cannot remain the same, applying to all conditions. In Board of Mining Examination, this court observed that natural justice is no unruly horse, no lurking landmine, nor a judicial cure-all. The court held that the last violation regarded as lethal objection is that the board did not inquire of the respondent independently of the one done by the regional inspector. Assuming it to be necessary, here the respondent has, in the form of an appeal against the report of the regional inspector, sent his explanation to the chairman of the board. He thus has been heard, and compliance under Rule 26 in the circumstances is complete. Natural justice is no unruly horse, no lurking landmine, nor a judicial cure-all. If fairness is shown by the decision maker to the man proceeded against, the form, features, and the fundamentals of such essential prosecutorial propriety being conditioned by the facts and circumstances of each situation, no breach of natural justice can be complained of. Unnatural expansion of natural justice without reference to administrative realities and other factors of a given case can be exasperating. We can neither be finical nor fanatical, but should be flexible yet firm in this jurisdiction. No man shall be hit below the belt, that is the conscience of the matter. Malad, kindly turns over to the next page. There is the continuation of the quotation, being quotation paragraph 15 at 757.
Yes.
These general observations must be tested on the concrete facts of each case, and every minuscule violation does not spell illegality. If the totality of the circumstances satisfies the court that the party visited with adverse order has not suffered from denial of reasonable opportunity, the court will decline to be punctilious or fanatical, as if the rules of natural justice were sacred scriptures. Now, my lord, with regard to the electronic evidences which has been produced in the writ petition as well as consequently in this appeal, my lord,
a point of 65B has been taken by my learned senior, my lord. This point has been very recently dealt with by the Supreme Court, my lord, in the education scam matter. That is 2025 SSC Online SC 719. SCC Online SC 719.
65B in all its regards in a writ
Petitioner will not apply. That is what has been held in paragraph 39. Mala, I'm grateful to you.
And this point has been taken. Dwell much on that. Whenever it fell from the court, he.
But I'm not placing it. Then
No, definitely place it because this is important because all of us feel so, and the Supreme Court also feels so.
Yes,
Supreme Court's feeling has the overriding effect on our feelings.
Right.
Which paragraph is it?
Paragraph 39. Mat 12008. Mat 12008 ready for that. Malad has found it, Malad.
Yes,
it is.
Otherwise, it will be like stretching the principles of natural justice. Stretching the principles of evidence.
Trying to be very
do that
as short as possible because I want to deal and complete with the decision beside it. It is also submitted by the tainted candidate that the certificate under Section 65B on the Indian Evidence Act is inadmissible and thus the said data is unreliable. In our opinion, the issues of authenticity of the data, which is the mismatch between the data set and the admissibility of the certificates under 65B of the Evidence Act, need not be decided in these proceedings as it falls under the purview of the criminal court. However, suffices to state that the Evidence Act does not strictly apply to the proceedings in a writ court and the decision is rendered based on the evidence and materials on record. So it will not, Malad, in all its regards apply in a writ proceeding. Now, Malad, your lordship will kindly remember that the point taken, one of the point taken against the private respondents and also meaning against our consideration is that the private respondent has given a land which is designated as Bashbagan.
Yes.
Now, Malad, this falls out of a condition. If your lordship kindly takes the vacancy notification once, which is starting at page 46 of the stay application.
Yes.
Your lordship may be pleased to take page 48. Starting at page 46.
Yes.
Page 48, kindly towards the middle, kindly takes capital A in the case of ownership.
Yes.
Or shared ownership. This is the point that the photocopy of the record of rights raised.
Yours is an ownership or a lease?
What?
Yours is ownership or lease? In this case,
private respondents is ownership. That your lordships will find, Malad, at page.
Yes.
Malad.
They produce a deed.
Yes, they have produced a deed and that is recorded in my inspection report at page 48 of the stay opposition. Page 48 of the opposition. Now, Malad, be that as it may, Malad, your lordship has dealt with this point.
Yes. This is
in Mat 1300 on Friday, though, Thursday. Well, on Thursday.
Yes.
Malad, the point taken by my learned senior.
Yes.
Same objection was taken by the state in paragraph 18. Your lordship recorded in paragraph 18. I'm not reading it, Malad.
Right.
That the land was, Malad, the relevant paragraphs is 18, 35, 36, 38, 39, 40 and 41, where your lordships have held that this is not an essential criteria at all. Therefore, if it is not an essential criteria, what is there in the ROR or in the lease deed, but I as an authority, I cannot reject it. At the most, if it is wrong, they will not get a sanction plan for building. But I will not be able to reject it
You
in
are
any
not
way.
that authority.
I am not that authority. Now, my lord, if your lordship kindly takes the decision which has been cited by Mr. Sarkar, my lord, 3 decisions I had already mentioned on the last occasion.
Yes, you
that
had.
is 2006 4 SCC, 1993 1 SCC, and 1994 5 SCC. But all these are otherwise distinguishable on the point that the writ petitioner has not pleaded the prejudice anywhere in their pleadings. These are also distinguishable on a common point that these are all pertinent to disciplinary proceedings. But even otherwise taking, if your lordship takes 2006 for SCC 713, well, this has been distinguished in a later decision of 2006, volume 10 SCC 572. 6, volume 10 SCC 572, paragraph 16. 2006 10 SCC 572, distinguishing your decision of 2006 4 SCC 713.
And this is paragraph
16. My lord, in that case, cited by Mr. Sarkar, my lord, there was a civil suit which had already held in the favor of the writ petitioner therein.
All right.
My lord, in our case, my lord, there is no such fact. My lord, your lordship will find at paragraph 16 bottom 4 lines. The fact of that case are distinguishable from the facts of the present case. In the present case, there was no civil suit filed in which the decree was passed in the favor of the appellant. This decision, therefore, would not be of no help. But the other decision, that is 1993, volume 1, SCC, page 13, cited by my learned senior, that has been distinguished in 2008, volume 8, SCC, page 92. 2008, 8 SCC, page 92. Paragraph 37.
Legally distinguished or factually distinguished?
Factually distinguished করেছে, legally তো applicable ই নয়. 37. The next decision relied upon by the respondent in the decision rendered by SBI versus DC Agarwal. In that case, the inquiry officer recommended exoneration of the employee instead of acting on the recommendation. The bank directed the inquiry officer to submit the report through CVC. CVC disagreed with the findings of the inquiry officer and recorded a finding of guilt and recommended the imposition of major penalty of the removal. A copy of the CVC recommendation was not furnished to the employee. The disciplinary authority, acting on the recommendation of CVC and agreeing to CVC's finding of guilt, passed an order but imposed a punishment lesser than that of the CVC. This court held that the order of the disciplinary authority imposing punishment was vitiated as it violated the principles of natural justice by denying a copy of the recommendation of CVC, which was prepared behind his back. The said decision therefore related to CVC examining the facts of the case and arriving at a finding relating to guilt contrary to the finding of the inquiry officer, and such finding being accepted by the disciplinary authority without giving opportunity to the employees to comment upon the CVC report findings so and so. In this case, as noticed above, the inquiry report relating to guilt was not referred to the opinion of the Vigilance Department at all. The Vigilance Department neither expressed any view in regard to the finding of the guilt recorded by the inquiry officer, nor did it reassess the evidence or arrive at a finding different from that of the inquiry officer. It merely opined that the case was not fit one for showing leniency while imposing punishment and left it to the appointing authority to take its own decision in the matter. Therefore, the decision is of no assistance. In our case also, the principal secretary ultimately took a final decision. If at all those decisions are applicable on law, that is. In that same page, the other decision cited by Mr. Sarkar, that is 1994 5 SCC 118, is also dealt with in the very next paragraph, at paragraph 38. That is Muhammad Karamuddin versus State of Andhra Pradesh. In that case, the Chief Vigilance Commissioner report, which formed part of the report of the inquiry and which was taken into consideration by the disciplinary authority, was not supplied to the employee. It was held that the omission was vitiated the order of dismissal. The said decision is also of no assistance.
Same ground.
Yes. Karamuddin, your lordship will find is ultimately a decision on limitation. That there the tribunal ultimately held that had it not been for limitation, I would have interfered with the order of dismissal. But I am not doing so because there is a long time has gone by. And invoking Article 58, the tribunal did not interfere. There the Supreme Court, found that finding ultimately was discussed with regard to the merit, that why the Vigilance Commission inquiry report was not given to the delinquent officer. But in fact, it has been dealt with in a 2025 decision also. By the time Mr. Sarkar will not probably start today.
And as you said, disciplinary proceeding probably
punishment.
Much higher footage.
In 2025 decision, it kept on striking me that why this standard? Because what the person is being visited is a civil consequence. His entire employment will go or something will happen to him.
Two things. One is the consequence, the penal or civil, whatever consequence. And secondly, he's an existing employee.
Existing employee.
He has certain
vested rights.
Vested rights.
Which he will get once he becomes a licensee.
Yes.
Once he becomes
at the threshold, he cannot
ask for those rights at the threshold. Now, my lord, another important decision has been cited, that is 1989 1 SCC 764, that is HL Tehran.
Yes.
Now, my lord, in HL Tehran, your lordships will find in paragraphs 11 and 12,
yes,
that the committee, the 11 and 12, I'm reading, my lord, paragraph 11 bottom. HL Tehran is 89 1 SCC 764. 89 1 SCC 764. না না তুমি যেটা দেখিয়েছো
HL Trehan, you have
HL Tehran দেখিয়েছো না একটা 89 1 SCC 764 paragraph 13 12 or 13 দেখিয়েছো
12 13 were relied on by them.
Yes, but your lordship will find in paragraph 11 bottom
Yes.
that admittedly the employees of Coril were not given an opportunity of hearing or representing their case before the impugned circular was issued by the board of directors. The impugned circulars cannot be sustained as it offends the natural justice. Here that is not the case. At the appropriate stage they were heard, but then the inquiry was directed and on the basis of the inquiry report the order was passed. But similarly, your lordships, they have shown 2020 volume 17 SCC 577.
Yes.
But there your lordships will find at that is relaxation of essential tender conditions.
Right.
But if you go by MAT 1300, this judgment is no longer required because your lordship has held that is a judgment on which is essential, which is non-essential. Today, interpreting clause 10, sub clause A, your lordship has held that it is non-essential.
Even if you go by this, then
So 2020 is not applicable in our case. And then 2023 SCC online SC 1408. That is the essential condition of both. 2020-17 and 2023 both are with regard to essential condition.
no, the 2023 SCC online says
Relaxation of essential conditions
should be advertised. Part of relaxation should be advertised, something like that. That's on note. There cannot be any relaxation in terms of conditions unless such a power is specifically reserved in the advertisement.
That is, rules of the game cannot be changed. The rules of the game we have not changed.
Rules of the game.
We are playing by the same rules. But merely because you have lost the game, you cannot ask the court to stretch the natural justice to a
No, you are putting it on a notch higher in the sense that there is no relaxation at all. Bamboo Grove record of right is not a determinant.
Not a determinant factor at all. I am putting it there, those are the decisions cited by my senior. I have completed my. Mr. Sarkar can start.
Yes, Mr. Bhattacharya has his right.
Oh, Mr.
Jingle Bhattacharya. Yes.
Kindly come to the pleadings of the my landed senior friend has raised that we have said.
Mr. Bhattacharya, shall we start tomorrow because I have a different bench. So
Instead of tomorrow, can it be day after tomorrow? I have some.
yes, if Mr. Sarkar does that, you are finished. So Mr. Sarkar, it depends on him. Day after tomorrow. Heard learned counsel for the state. Full stop. You are the state, aren't you? Or
I am for the state.
State. The state or some, yes, state.
State.
For further hearing of learned counsel for the private respondent, as well as rejoinder reply by the petitioner, let the matter stand adjourned till August 27, 2025.
Good.